Oh, there it goes. I don't know why this one ain't coming up.
Top two.
Yeah, yeah. Six isn't coming up.
I'm trying to think. Um, six is in number one.
Let's see. Yep.
Okay. So go to the menu on six and go to the first tab. I mean monitor. I'm sorry. Second tab. Go over. You see those arrows on the right and left? Go over. What does unequivalent number? One more. Oh, I'm sorry. You see where it says LCD?
Yep.
Click main SDI
Oh.
and go over. Okay, so change at the bottom left where it says 2160p. Go to the left and change it to 1080p. And then come out the menu. It should come up.
Yep.
Yes. All
Bet.
right, bet. Yeah, we're just wrong. 4K.
Okay, bet.
All right.
All right.
Oh, that's what I was calling. You see the computer coming up on the PowerPoint?
On the switcher, yeah, it's on the switcher for. Yep.
All right, bet. Okay,
Okay.
cool.
Bet. All right.
I was gonna say the other little toy. Hey, how you doing?
How are you?
Good.
I got
You okay? I'm just setting,
okay.
just,
Yes, thank
just,
you.
just hang out, watch you be great. Morning. Oh, we finally meet.
Yeah.
Jayhan.
I've been calling you Jihan. Jihan.
Yes. Nice to finally meet you.
Pleasure.
The Chewy.
Uh-oh.
The legendary.
Uh-oh. Uh-oh. I better be careful now.
Oh my goodness.
How you doing?
I'm good.
Okay. I thought that was a radiator.
I thought it was too. When I came in here.
What is that? What is
I
it
was
for?
wondering too. I think
I
it's to
guess-
stop people from falling out the window, maybe.
Right. Go. Yeah. Keep the jumpers in the room.
I did, I asked, I said, I asked them. Yes.
Latoya, I hate to interrupt. Can you back out so I can make sure our proper wills and trust fund is in the folder? Because I know Lori had sent like everyone we've ever done before. And make sure.
NAACP.
Okay, yeah, there we go. Yeah, I got scared because I saw all the old stuff. I was like, Lord, I done sent the wrong files.
So, and then just let me, okay, so we're gonna do this one, the wills and trusts, right?
Right.
This is the right one.
Yeah.
And is it this estate?
It's
Not
the tenant right one. It's the
This
same.
one.
Ayana's doing that one.
Okay, so it's just these two.
Yes, ma'am.
Okay, I got you.
Okay. I saw all the, I said, Lord, I didn't send Lord wrong. I was gonna make it work. Don't even worry about it, but.
Okay. All right, so, yes, I did ask, so, in the, I will, so yes, hopefully they come, but in the interim, the people that are on the Zoom, they have this link to this folder, so they might just have to look at it that way until we get the forward. Yes. So, well, okay. See, well, it's a button here that says HDMI. Yes.
I stuffed my face with a breakfast sandwich on the way here. I mean, stuffed.
It works.
It works. But thank you.
Now, it's another one that says computer.
Hello.
So when we did our walkthrough,
How you doing?
Good, how about you?
Good.
they
Good to see you.
tested the ports and they turned this on, but,
Good that it touched the, speak with the HDMI.
and I
Probably
think,
went back there.
I think they just made the assumption once they cut on and everything, it was all,
Yeah.
That's fine.
When I was pulling the state over there, I had to fly out to see all this.
Oh, I'm sorry.
So,
I'm sorry.
leaving at 8 in the morning, I got a whole bunch of.
Yeah, yeah.
So I just be spending in there, of course,
You're still. Okay.
How's everything going with the, books?
Been going very well. Been going very well. I'm tired. Been going very well.
Good, good.
morning, how are you?
Good.
Leon, Latoya, Latoya, Leon.
Yes, nice to meet you, thank you for participating.
No problem, thank you for having me.
But yeah, going very well. So there were a few stops that I was gonna originally wrap up in fall out of state that I'm gonna move to the beginning of next year. There was one, because I was originally gonna do Chicago at the end of September, first week of November, LA. The September, one of the main hosts, his mom passed. So obviously he off grid, I'm like trying to get us in, let's just go ahead and move it. And in Chicago, so we're not doing it in December, January, February, or March for that matter. So I'll see you in the spring. That's not happening. And they're like, we want to do this Black Thanksgiving weekend. I said, do I want to spend my holiday weekend? You know, because they want to do it on Black Friday, which I get, like the whole thing, like, well, but I was not even gonna be able to do it. And then the folks in LA, him just turned into like a marketing kid. I'm not even joking, like that's really it's honestly, it's to the point where it's like, okay, what's happening is super tragic. They literally since June have been done every other week. I mean, and they have a big family, but still. Yeah, so anyway, obviously it takes folks off the grid when you don't plan.
We are logged in this way.
You know what I mean? It's just like, let's just be smart about this.
We can't find HDMI system.
to.
Unless you got a longer cord and
Jim.
you're probably about to.
See, I told you.
And, you got the head everything. But then you just.
Oh, yeah, the broker?
Yes,
I asked him.
yes, and she has
But they got
somebody
like
else,
11 things.
and he spoke so hard.
It's packing every first time. And I was.
Yeah, they got like
And I
4
parked
things.
on the side. Wrong good.
That's kind of the agent that I actually just kind of met him, but I've been working with Nate for a
So
while.
then it has to be him.
He just went over to her broker. So I'm
Okay,
pretty sure
okay,
it's him, yeah.
yep, so it has to be him.
Hi.
So they're doing some cool stuff, so,
She told you about her nonprofit
Mhm.
doing that? Yeah, that's what I was saying. So,
Yeah.
Yeah.
yeah, so, it was a good call, so.
Yeah.
Yep.
Yeah, she got a lot of plans. I know. Well, Nate, like I said, I've been working with him for a while. He had some issues with his other program.
Do you log in or you have?
We got a big call on there. She was telling me about a whole bunch of
Or
plans.
I don't have a camera.
She was like, I'm looking for an attorney officer to be able to help.
Get them to share.
Yeah.
Yeah, she's gonna be doing, if she follows through what she says.
Yeah, what she said she's gonna be doing, it's gonna be amazing, I told her, I said, yeah, I know folks are gonna, like, unique things, not this,
Yeah.
so. She'll be good, I'm excited.
Yeah, definitely looking forward to helping her.
Mhm.
Oh, I was gonna actually, Patrick Sherman?
Yeah, Pat, yeah,
Okay, he said he had went to school,
Yeah.
elementary.
yes,
Okay.
yeah, it is big.
Well, I had posted the flyer a couple of days ago.
Yeah.
And I tagged him, and he was like, "You know Gina?" I was like, "I met her about a year or so ago." She's like, "I was like, we do some work together." He's like, "I went to school with her."
Oh my gosh, I've not seen, I can't even, it's been years.
Since then, like,
Yes,
possibly?
yes,
Yeah.
yes. Possibly.
Nah, we used to box out the same gym in Flint
Oh, okay.
back in 2010 through 12.
Yes.
And then I left, that's when I moved out of Flint, but we still down there.
Yeah,
We still keep in touch, obviously.
okay, okay.
He's like, "Man, you
Small
know,
world.
He's like, "I didn't know you went to school, middle school and high school."
Yeah, small world. I hadn't
Robert
heard
had to
that
go
when
back
you
to
said
the
that.
ranch.
Yeah, I know.
Actually, that's my guy.
Okay.
It's at the door.
He's doing good.
Yeah, he just opened up a dealership, car dealership.
Okay, so you're saying,
He
because
did
he
have
is gonna be
one
logged
business
into.
Okay.
before, him and his family kind of got into
Right here.
some head knocking, so whatever.
Start.
He's not in the business anymore. He's still-
I got a switch back there.
Yeah,
I was switching between cameras
Okay.
and power.
Good, good.
that's what I was saying, that's why, because he,
I'm confused.
so it's normally how it would be. Normally,
I forgot.
Roy would be in the back and he would be plugged in so he could switch between
I
the
mean, the two, not us.
Oh,
because
You
he
looking
would
like-
probably.
Oh, you
he
been
would-
talking.
he would
I
connect
just told you.
So we
I
got-
got-
This is,
Problem
I mean, this
job.
room setup is different because it's not like, that, so.
About to create some more stuff done before I
He's
leave.
already, so when I talked to Roy
I
yesterday,
thought all
he
the
said,
way across the
to
face.
me, all
Like,
the shit. So he's
like,
already, Roy's already.
You need to tell
logged
me.
into
We couldn't have.
the restream that they have that's going to the
Yes.
Facebook and the YouTube, so that is already set. So what
You
I'm
was
saying,
saying, I'm gonna say myself. She'll be. I'm gonna take it.
Oh, yeah.
Every single time. I'm not. I didn't realize it. In that shot, that she was
Yeah.
See, this is there because we didn't have the HDMI.
Okay.
That's why I asked the tech, sorry.
Okay.
So,
This is
this is, when you approved me, I had to
okay.
pay.
Well, I need you logged in on Zoom here, not here. I thought this was operating this screen.
No,
Okay, I need you logged in on Zoom here. Yeah. There we go.
Yeah, it doesn't have a HDMI outlet. Yeah, that's why.
You don't have a locker for it? Maybe.
Is there a way to pull it out? It's right here. It's my Mac.
So like, how's your slide stance, you know? Where is this your slide?
That one's me, yeah. That one,
How are you projecting it?
oh, cause I'm on the.
You can't switch between on that one. Let's try that one before I figure out how to do this. I'm looking at the thing.
Attorney Matt. How you doing? Good to see you.
This one, we got your green.
Don't worry about it, man. Here, that's all that matters.
No, look,
You
it's the
here.
same.
Okay.
I found HDMI.
Oh, it's.
Pretty much, yeah. That's something new coming up.
QR code.
Yes. Oh, okay. You need some executive session up in the tree.
Transfer underneath the
Not of the
plug
week.
this into
Exactly.
switching the situation.
Exactly. That's it, or if I get the call.
Especially with me, it wouldn't be like. I'm
The Homer dough. Well, we were trying.
I did log in using this keyboard, but we were trying to originally.
Yeah, we wanted to. So.
Even though there wasn't a mistake open, I couldn't even understand if he made some sort of notation. He literally signed it.
Oh, wow.
And I don't, here's the thing, I do not think he superseded it. But he, yeah, he literally, not only defraud, it's also like fraud, like, that's actually criminally actionable.
That's a decent law, yes.
So I was like, let me drill down to this, so I can understand from your perspective what happened. I said, okay, did you know to do that? And he said, I'm just trying.
Just to make sure, yeah.
And it's only one HDMI outlet on this laptop.
Like, you need to put that into it?
Yeah.
So you know what?
Do y'all have a locker HDMI?
We do, the only problem is that it's connected to here, like inside of the wall. So you're gonna actually adjust that with your. So only it was, that's the actual. Like,
She said she didn't want it.
Spot, right?
So anyway, it doesn't stop there.
The HDMI?
He flipped it and then instructed somebody else. Exactly.
everybody.
Morning.
We're having a few technical difficulties, but we will be starting very shortly, so thank you for being here. I'm glad you brought your patience. Thank you.
I think,
Yeah, it says it's linking, so we're about to see. Waiting for this one to pop up.
oh, yes. And this is for, like a live stream?
Mm-hmm.
Okay, I know you guys are looking into some situations.
It says please check video source.
Let's look in the HDMI. Are you still?
Yeah.
Yeah. Are you recording? Okay. Does it need to be on the same input as what's being projected? Well, no, that would make sense.
Jason, nice to meet you. Nice to meet you.
I have a situation in my throat, and I lost my brother back in 2023. Was she going to a health issue in 2018? Did she, well, she had MRI.
No. Not working.
Well, the way it works, it should just be, it would just plug in, you would just see it over here.
Yeah, it would just pop up, because when I plug into the laptop, it pops up. So,
Should I go into laptop directly then?
well, we wanted it to go to the laptop,
Oh,
yeah.
one is my computer, right?
Yeah, it's only one HDMI port.
And it's not using the laptop, right?
He set aside the deed, did he set aside? He voided, okay, he voided it. Okay. And I have a will. So he, what year was how you got on the property? There was never. So how you, okay, all right, we'll talk.
Okay.
Yeah. So you just get your card.
This is now.
Now they have a purchase
This is about
agreement, sell the house.
Oh, really?
They all do the same.
I'm not, it's on one, I think it's that, and right here, it says, I'm tonight.
Fortunately.
Yeah, it's all the time.
And that's, yeah, it is, yeah.
Thank you. Okay.
This ain't working. It's not coming up. Right there.
They sued that last time, Stewart tried to DUW
Okay, so,
Oh, they gave it to
those that are
everybody get available.
they have.
This transaction, and you are paying this.
Like, I mean, we'll put it in here. You just gonna have to.
See, yeah, that's what I was gonna say. You want me to just shoot this? Okay, I'll have to get the line on here. And the other camera on you or whoever's speaking.
Yeah.
Okay.
Literally, because there's some random names up here.
Right, you said I can.
You too. You
Oh,
too.
They got it projected.
Okay.
Round them up, round them up.
And for the click, they can just click their side to it. They have links that level, they have links to camera, right?
Get them in here.
I'm about to tell them in the chat, I'm gonna drop the link to get to the thing,
setup?
So I can like move it.
I got a cord plugged in from the camera into the speaker.
Alright.
Okay, and I can make it.
It's not plugged in right now,
Yeah.
it's usually plugged in.
So then we need to be able, once they come, they can.
Anything else you guys need?
I'm gonna show the video.
I think that's it for right now.
Okay.
Yeah, sorry the setup didn't
Oh yeah, no, I'm sorry.
I'm
Yeah.
not 100% sure what it is.
Yeah.
Oh, it's you gotta scroll it down. Oh no, it's this one, sorry. TC.
Try to get back downstairs. But if you guys need anything else, we can try to. If there's any more problems, I can try to come up here and help out. But for now, if everything's good, shoot it now.
Yeah. I know. All right. Thank you.
Alright, no problem.
She's made
Oh,
one
it's
copy.
TC. I just, sorry.
She could have printed. We got 4 printers in the office. But she's program is really one of our cornerstone programs. Because we stand on the shoulders of the giants who come before us, who laid the groundwork for everything that we're going to do from now on. So now who am I talking about? First of all, we got, this is a George W. Crockett Jr. Community Law School. It is a law school. You will learn the law here. You won't have to go in debt like most lawyers do in order to get your legal education. Free. But it's part of an initiative we call the Thurgood Marshall Ruth Bader Ginsburg Legal Initiative. We call it that because they are giants. They are trailblazers. They blaze trails for us. Thurgood Marshall, the first African-American justice on the Supreme Court of the United States. Ruth Bader Ginsburg, female trailblazer who was really supportive in many, many ways. But it's really about George Crockett, who was a giant in the legal community of Detroit, who stood up for us. Everybody was throwing knives and bullets and rocks and everything else at us. George Crockett was there to protect us. As a congressman, as a judge, as a lawyer, he went to jail from time to time. He protected us. That's something. So this is about George W. Crockett. This is about the NAACP. This is about the Detroit branch. Tell you a little bit about the Detroit branch. We have a wonderful president who's been our president for over 30 years. He is our leader. He is a major reason that we're able to be here today. We have an executive committee. We have a executive director, Amelia Landon, who will be heard later on today. We have executive committees are how we operate. The executive committee is like a board of directors. They make key decisions about the direction in which the NAACP, the Detroit branch, moves forward. Each executive committee member has to chair a committee of that executive board, what I'm going to call it, to avoid redundancy. And several of our committees are, relative to today's presentation, a criminal justice committee in which we address all kinds of criminal justice issues, and a legal redress committee. We're lucky today to have the chair of our legal redress committee here, who will be coming before you multiple times this morning, introducing folks and helping you to gain access to this valuable information. His name is Richard Mack. He's a local attorney here in Detroit, major law firm, partner in that firm, and I'm just glad Richard to come on, because you know, technology is great, but sometimes it slows us down. And so it put us a little bit behind this morning, but we're going to catch you up. Pay attention, and you will be amazed at all of the great information that you will hear this morning. Richard, please.
All right, thank you. Greetings, good morning everybody. Thank you again for coming here. As Julie said, we are always excited and pleased to be able to bring you valuable legal information. We've been doing George Crockett Law School at the branch for, a couple of decades at least. I'm showing my age a bit. But, so yeah, today, well, let me just a little bit about, and Julie mentioned the structure of the branch. The Legal Redress Committee is a committee within the branch that handles legal issues. We do all sorts of things like, literally, just a couple of days ago, I got a call from someone who's challenging racial discrimination that they're facing. So we'll investigate those matters and we'll reach out to legal research and potentially even file lawsuits. We've had to, the Legal Redress Committee sued the Michigan Republican Party a couple of times to get injunctions against them from interfering with the election process. So there's a lot of things that we do, and one of the things that we do is the George Crockett Law School. As a plug, on October the 30th, please come out to the branch. We will be doing election protection training. So we have an election coming up on November the 4th, and that's election for mayor, and many municipalities around the state of Michigan have elections this November. And it's important to have people who are at the polls protecting your right to vote. One of the things that is a cornerstone rights that NAACP fights for is making sure that we have the right to vote. We're seeing in Michigan's United States Supreme Court, rather, they're considering an appeal which may eliminate for many black and brown people across this country the right to vote. And NAACP is involved in that. So we're always going to be involved in that, and we want you to be involved in that. So again, October 30th, 6 p.m. at the branch at 8220 2nd Avenue. Please come out and be a part of the election protection process. It is my privilege to get no further ado to get into the meat of this program. And I am going to introduce a young man who's going to give you a lot of information about titles and the ability to make sure that you understand what the title process, the real estate process, buying and selling land, what is the importance of a title, deed, and all of the rest of that. His name is Leon Mallett. He's a 12-year veteran in the field of real estate. He's got a bachelor's degree from Northwood University. He did a dual major in banking and finance, and he currently holds the title of mortgage loan officer, and he works for the company Title Connect LLC as an account executive. He's active in his community. He gives back all the time by working with disadvantaged youth, including an internship program he started for students at the Job Corps in the Flint area, Flintstones, in 2008. He also gives back by coming to present information to people like you about the process of title. So without further ado, Leon Mallett, please take over.
Okay, good morning, everyone.
Good morning.
Okay, so I just want to touch base with you guys today regarding title and answer some questions that you guys may have pertaining to it. First thing we'll start off is what is a title company? So a title company is a neutral third party for a transaction. It is our job to make sure that everybody's best interest is protected on both sides. As a title company, we have three primary functions. The first one is to provide title insurance. The second one is to maintain escrow, and then the third is to act as a closing and notary signature for the transaction. Okay, so what is title? Title is ultimately who has ownership rights to the property and or land. It basically determines who has the right to the enjoyment of the land. It also can potentially determine limitations on the ability to sell, as well as it acts as an insurance to mitigate risk. Now, when it says mitigating risk, title insurance, a lot of people don't know what it is. Basically what it is it's an insurance that's put in place that makes sure that if there's any type of title issue that transpired prior to your ownership, that you will be able to get financially made whole based off of it. Now, when it comes to insurance, it's the same exact thing as any other insurance, albeit your car insurance, your health insurance, or anything else. The whole purpose of it is to shift the responsibility from you, the consumer, over to the company as far as any financial obligations. So, no different than, like I said, car insurance, health insurance, or anything else, we do the same.
Six times a charm?
Go ahead.
Okay. All right, so title insurance. So as far as the policy goes, so the first policy is your owner's policy. So this is the type of policy that is issued that assures that the buyer and seller that the property is being delivered free of any liens or encumbrances. Does anybody in here, besides the attorneys, know what a lien is? Yes, sir.
It's a charge against your house, monetary charge. With someone who has a vested interest, say like a builder, or not a builder, but a contractor or someone that has done some work or has a interest in the property.
That is correct. So basically, what it is just stating in effect of who actually, as far as a lien, it's basically anybody who has an interest in the property. Now, he gave an example of a contractor. Somebody else who can have a lien on your property is your mortgage company. Exactly. Until you pay that off, they technically have a lien against that property, and they have a vested interest in it until you pay the mortgage off. So there's different optionals as far as it goes when it comes to liens, but that is correct as far as that goes. Now, in terms of the owner's policy, again, what that does is it assures that you as the buyer are going to be made whole in the event that there is a title issue that came up that was not found on the search prior to you getting your warranty deed when you make the purchase. So ultimately, that's what the owner's policy is going to cover. Now, the lender's policy is in the event that you're going to be getting financing on the home. It doesn't necessarily have to be good a purchase. Let's say you buy something in cash, but then down the line you might want to do a cash out refinance. If you buy it in cash, you won't have a lender's policy. But if you do get financing, albeit with refinance or even using the financing to purchase, you will have to get a lender's policy. And ultimately, what the lender's policy does is it assures the lender their lien position in that transaction. So in the event of something happening, let's say where the house was foreclosed on, you might have two mortgages on there, one for $200,000 and another for $50,000. Basically, the lender's going to probably want ultimately the highest lien position they can get. Usually your standard mortgage is going to go into the first lien position. But let's just say when the foreclosure happens, there's only $175,000 in proceeds that happens. That one lender who has the $200,000 being in first lien position, basically they're going to be able to get that full amount of that $175,000. That second lien position who has $50,000, unfortunately they're going to be left out because there are no more proceeds that are going to go to them. And that's what the lender's policy does, is it basically protects the lender's lien position in that transaction in the case of a foreclosure or something where proceeds have to be paid out from the situation. Now, as far as policies goes, policies are issued off of what is known as a title commitment. Basically, what a title commitment is it's the best way to look at it is it's the policy being given to you by the title company. And the way it's established is by doing research through county records, registered deeds, courts, municipalities, to verify any type of liens and or issues that may crop up as far as any lien or title issues for your purchase when you do it. So with the title commitment, you do have conditions that you have to meet in order to be able to get these policies. Just like if you're getting a mortgage and the mortgage company says, hey, I got to verify, your last 30 days of your pay stubs, or I got to verify the last 2 years of your work history. I need to see your bank statements to verify you have money for your down payment. Those are conditions for your mortgage. Same thing happens on the title commitment. The title commitment may have a condition that says, hey, this mortgage obviously has to get paid off, or there is a tax lien from the county that needs to be addressed, or there's a contractor's lien that's listed under from a contractor who put a lien on the house 5 years ago for whatever reason. All those commitments have to be made and suffice before you're able to get your title policy. So again, just like your mortgage, same thing happens. You have those conditions that you have to meet. Ultimately, once you meet those conditions, at that point in time, that's called clear title, and then at that point in time, you'll be able to go through and get what's known as a warranty deed. Now, when it comes to insurance rates when it comes to title companies are going to be the same pretty much across the board. The state ultimately controls insurance rates and also the underwriters, and pretty much every title company typically uses the same main 4 underwriters. So you won't see a lot of variance in when it comes to insurance rates from company to company because, again, those are set by the state and by the underwriters. Now, escrow. Again, as a title company, we also act as a escrow agent. So an escrow account is a non-interest bearing account where funds for the transaction are held. Ultimately, the reason why it has to be non-interest bearing, that is a governmental rule. because it can't be a situation where we're taking your money and we're trying to gain interest on it and obviously profit off of it. So any type of funds that are used for your transaction are held in this account, and they're used specifically for the purpose of your transaction. Now, there are two situations when it comes to escrow that happens for a transaction. You have your incoming funds. So that's going to be your earnest money deposit, which is going to be required typically when you go under contract. And once you have your earnest money deposit, that has to be put down in front. Funds from your mortgage company, obviously when you get ready to close, they're going to send the funds over for us to be able to send them out. And then outside third party. So let's say if you have a gift from a family member who's going to be helping you out with the down payment. Ultimately, they will send the funds over and we will act as an escrow agent. Now, keeping in mind as far as the earnest money deposit, typically it does go through the title company, but you do have the option where you can send that to your realtor's brokerage as well. That's a conversation you would have to have with your realtor as far as who would handle the earnest money, but ultimately you are allowed to send it to your broker and they can keep it for you for the transaction. Most of the time, like I said, it goes to us. In terms of a transaction, never ever do anything pertaining to finances outside of the title company or your broker. Never give a seller your deposit. Never give them any type of money pertaining to that transaction. Everything needs to go through the title company. If they say, okay, well, yeah, you can buy my house, but I need a $3,000 deposit, you give them that $3,000, and something goes astray and they walk away with it, you're pretty much going to be up the river without a paddle. So at the end of the day, you need to make sure that all funds for any transaction go through the title company and or your broker, and that's ultimately to make sure that you are protected throughout the transaction. On the outgoing side, obviously, like I said, we will get funds from your mortgage company when you get a mortgage. At that point in time, we have to pay off anybody who has an interest in the property at the time. So the seller may have a mortgage that has a balance of $100,000. So when we get the money from your mortgage company, that portion will go to pay them off. If there are any water municipal bills, ultimately those will get paid off through us as well. Any liens on the property. So if that $5,000 lien that the contractor put on there obviously needs to be sufficed, so that may come out your proceeds. So again, we will handle getting that paid out to the contractor. And then also your homeowner's insurance policy, where if you do get a home, your homeowner's insurance policy, you do have to pay your first year's insurance premium up front at closing. And if you're going to escrow your payments, typically the lender's going to want you to have usually 2 to 3 months of escrow on top of that as well. But as far as the initial payment to your insurance company for your first year's premium, we can disperse that through the closing of your transaction. Now, we also act as a closing agent. So we are a notary sanctioned by the state. So basically, as a closing agent, we handle all the signing of your documents when you make a home purchase. That's going to also include your loan documents from your lender, your deeds, your settlement statements, and anything pertaining to that particular transaction. Now, one thing I do want you guys to know is that when you guys are in a closing is technically an untimed event. Untimed meaning that you have as much time as you need to sign your documents. If you have questions about anything, make sure that you ask them before you put your hand on that signature, or before you put your hand on that document. Ultimately, you are responsible for anything that your signature goes on. And if you're going over something as far as your lender documents and you see something that says, oh, it can adjust in 5 years or anything, you have a question about that, before you sign that document, you need to ask that question. It's our job to kind of guide you through what the documents are. Now, there may be a situation where, let's say you say, hey, why is this adjusting in 5 years? Technically, we might need to get your loan officer on the phone and say, why does that state that when it was never discussed with you? But any documents that you have, like I said, you have an untimed event to be able to sign your documents. There is no rush. And like I said, I advise you to go through them pretty thoroughly to make sure that you understand what you put your signature on. Because once you put your signature on those documents, you are responsible for that mortgage and or anything else that you sign. So once you are completed with your signing, you will receive a closing package that has all the documents that you signed for your transaction that you can be able to take home with you. I always tell people, make sure that you put that in a place that you can access easily and that you know where it's at. Not that you would hope to not need them, but there are situations that come up where you may need that information for some reason or another. And you want to make sure that it's easily accessible for you to be able to get if something does come up. But ultimately, once you sign your closing package or get your closing package, you'll get the keys to your property, and then at that point in time to celebrate, have home parties, and welcome to your new home. So, but in terms of the purchase process, that's kind of the basis of that. There's a couple other sections that I was going to touch on too. But did anybody have any questions about the home purchase process as far as the title? Yes, ma'am.
Do all of these, two questions, do all of the policies and processes stay in place when you're buying foreclosed properties, like from the land bank? And then also, for perhaps you were speaking to the lender's policy, and you were indicating that if a house goes into foreclosure, the first person can get this back. How does all of that work when, I'm just curious about the prices, like a lot of those are much cheaper when folks are buying them, they start fixing them, they sell, they may not be financing them. And so how do all of the protections come in place? Or like they're not needing protections since they're doing a cash system of going into home ownership?
Well, as far as on the lender's aspect, the lender's going to be, the amount is going to be based on whatever the loan is. That's the dollar amount that's covered, as well as on the owner's side is based off of the purchase price. So in terms of a dollar amount, that's where those are going to be set. Now, as far as, you said, what was the initial one you're talking about?
Like if folks are buying tax
From
properties
the
from land bank.
Okay, so typically, let's say if you buy a tax property, you're going to usually be issued that on a quick claim deed from the local municipality. I always say you might want to get a title search done prior to that. If you know, you already know the list of properties that are going to be coming. I always tell people if you're planning on buying a house from the auction that you get a title search done prior, and also get a FOIA review. FOIA is the Freedom of Information Act, and the reason why you want to get that done is because in order for a municipality to foreclose on a property, there are certain specific notifications that they have to give that owner prior to them foreclosing on the property. And if for some reason or another they did not get that properly done throughout the process, that person technically still has an interest in that property. So it's very important for you to give a FOIA review, or FOIA stands for Freedom of Information Act review, to assure that that previous owner got all their proper notifications during the process. So if you do end up buying it, you don't have to worry about them coming back and saying, hey, I didn't get my third notification that I was supposed to. I actually still have rights to this property. So FOIA reviews we do, as well as title searches. There's a fee to that. Our FOIA reviews are $250. Ultimately, if you're planning on buying a house from a municipality or an auction, it's worth getting done. Just look at yourself also. You have to look at it as an investment at the end of the day. It's better to spend $250 to do a FOIA review than drop $15,000 on a house and then ultimately find out you have no rights to it and $50,000. There is no warranty deed when you're buying it, like I said, on a quick claim deed. And I'll get to quick claim deeds here shortly.
If you had a situation where it was a condominium and the association foreclosed on the association fees that were owed, but then the mortgage company still had a debt for the mortgage, what would you need in order to issue a warranty deed in that situation for the person that ended up buying it from the mortgage company, say?
Well, as far as, are you talking about the person who's buying it from the foreclosure?
Yeah.
Well, ultimately, they'll be able to get a warranty deed through a mortgage foreclosure. A mortgage foreclosure is a little bit different than a tax municipality foreclosure. So most of the time, when it comes to a foreclosure, the house technically goes back to the bank sometimes, especially if it wasn't bidded on at the property. So they actually have rights and they're actually invested as far as the owners goes. But ultimately, mortgage is different than just a municipality because technically you can get a warranty deed when you buy a home from the auction as far as if a mortgage is involved. But like I say, if you're buying from the city on an auction, the tax foreclosure, this is a completely different situation.
Thank you.
Yep. Any other questions? Okay. So next, we will go into quick claim deeds. So a quick claim deed is a legal document that transfers ownership interest from one person, which is the grantor, to another person, which is the grantee. Typically, quitclaim deeds are used to transfer property between family members. There are situations though where people use it to just do standard sales, which we'll kind of go into a few situations on this. Now, quitclaim deeds, there are some benefits that come with it. It's a quick way to transfer property ownership. When it comes to a quitclaim deed, you don't necessarily have to go through the process of going through getting a warranty deed, meaning that you're not going to have to do title searches, things of that nature. And like I said, it's a simple way to just basically fill out a single page form and then get it filed, and then you're all set. Again, easy process to complete. There's very minimal paperwork. Like I said, you can pretty much do it on one form, and then it'll be all set. And it does save money. Like I said, you're not having to pay for closing costs, title search fees, and different things that you do to go through the normal standard process if you are going to be purchasing a home. So being able to do it that way, you pretty much would just have to pay a notary for whatever their fee is to do it, and then whatever the county recording fee is to file that. Now, there are some dangers of going to the quitclaim deed. First one is no verification of ownership. When you go file your quitclaim deed, the county's not going to look up do a title search to verify who's vested or who's the actual owner. Basically, a quitclaim deed is, like I said, it's a transfer of ownership interest from one person to another. You can go down there and record that quitclaim deed from this person who says, okay, well, I'm just going to assign you my interest in ownership. It's going to be on record, but at the end of the day, you might try to sell that property and you won't even actually have the ability to do that because technically you're not vested as the actual owner. So there is no title searches done by the county when you're doing these. So again, you're putting yourself out of one where you might be putting yourself in a situation where somebody might have an interest in that home. You pay somebody for it and then you're going to end up losing that money. Another thing is inheritance of unknown liens, encumbrances, and claim. As we discussed earlier, what liens are. If you're buying on a quitclaim deed, there's not going to have to be a mandatory title search being done. You can literally do that between two individual people without even having a title company involved. But if you're buying a house and this person says, oh yeah, it's free and clear, yeah, so go ahead and buy it for $50,000, you don't have to worry about nothing. And the next thing you know, there is a mortgage on there and that mortgage company hasn't been paid in 6 months. Now they're coming to foreclose on that property, and really there's nothing you can do at that point because you don't have a warranty deed, which means you won't get compensated for that, and ultimately you're going to get the loan where you might lose out on whatever estimate you made in that. And then, like I said, that's another thing, just the lack of protection and no warranty deed. You don't want to put yourself in a position to where you're not covered in the event of something like that happening. And I'll give you an example. I had one of my lenders send me over a deal 2 months ago, and it was for a refinance on a 9-unit apartment building that the guy was looking to do a rehab on. The gentleman bought the home on a quitclaim deed from somebody else who had bought it from somebody else on a quitclaim deed. When we did the title search, ultimately it was vested in the city of Detroit development, who actually was the owner. So basically, he bought a house from somebody on a quitclaim deed, or the apartment building from somebody on a quitclaim deed, and then that person who had bought it from somebody else on a quitclaim deed, that person never even had interest on it. And the guy who was trying to do the refinance, he had been paying taxes on it, everything was up to date, and ultimately, unless he goes sue the person, and he really can't sue the guy before him because the guy before him actually got, well, he technically can, I guess you could say, but he's actually got pretty much put in the same situation as him. They would have to basically go after the other gentleman who sold it to the initial guy on a quitclaim deed to try to get any type of legal recourse. This is why you don't want to buy on a quitclaim deed. Go to a title company, get yourself a warranty deed, because in the event of something like that happening with the title issue, the warranty deed is still going to be able to make you whole financially wise at least. You may potentially have to give the property back, but you'll at least be able to be made whole on a financial perspective. But when you go and you buy on quitclaim deeds like that gentleman did, now him and the guy he bought it from are both trying to find the guy that he bought it from, and he's nowhere near to be found. And now they got to chase after him to try to get both of their money back. And will that happen? I'm not sure, because I don't know where that guy is, or even who that guy is, but when you do stuff like that, you put yourself at that very dangerous for the president to potentially lose out because of that. So, but those the sense of quitclaim deeds. Anybody have any questions pertaining to quitclaim deeds? Yes, ma'am.
Okay, this may be track, but they keep showing this ad about house dealers where someone can, transfer your property to their name and then, you know, loan on the property, a loan on your property. But, how, so if that occurs and the bank comes to you or whatever with money, you have a report for that or you just stuck with it? Because it sounds terrifying on TV, you know, when they say, you know, people go and they change the deed and they take out these loans and work in and then the work comes after you to the money. So how does that work?
Well, going back to what we were saying as far as the lender's policy, in the event of that, well, first and foremost, the title company should have been able to catch that, I would hope, before that person can even do a full refinance. But the lender has their lender policy. The lender gets all the title work and everything before they issue the loan. So if there's a lender who's looking to do a mortgage on somebody who actually doesn't technically have legal right, that's on the title company and that's on that mortgage company. And ultimately, they're potentially going to be at the loan with just being out of it because they didn't do their due diligence in what they were supposed to do up front to verify who was vested on title at that time. So there are people that do deed fraud, especially in Detroit. It's a big thing. But at the end of the day, the person who's vested on title has that interest right. And if they never took that mortgage out, they don't have any obligation to that lender because they didn't take it out. And that lender ultimately might just have to ultimately eat that. But again, the title company, I'm assuming, issued them a lender's policy, which should make them whole, but the title company shouldn't even been in a situation where they're giving out a mortgage to somebody who, if they've done their due diligence through the title search, they should have had verified who was vested in the chain of title to not even go to that point to get them a mortgage. But ultimately, that person's not obligated because they never signed that mortgage document, and technically whoever signed that mortgage document was never actually the owner. So the bank just has to.
So they forged your name. I mean, they're forging your name on that document.
Are you saying? Oh, you're saying somebody forging the name of the owner?
Forging the name and on your property. Say I have like I own my home.
Yeah.
And someone else forged my name and does a quick claim deed and takes over the property. You know, so they're actually like they're the owner of it.
Yeah. Well, that's deed fraud at that point. As long as you didn't sign it and then you can prove it, you might have to do what's known as quiet title or something like for something like that. But as long as you can prove that you didn't legally sign it or you were not forced to sign it, you're not held liable for that because it wasn't you that signed the document.
They have electronic signatures.
Well, it has to be notarized. A deed transfer has to be notarized. Now, technically, you can do electronic notaries, but there's a process called it's called RON, remote online notary, that they do. You have to verify that person's information. You have to see the back and the front of their ID. You have to see their face. They have to take a selfie most times and send it over. There's a process to be able to do that online. It still needs to be notarized. So if that went through with a notary from somebody who didn't get verified, that notary was probably in on the situation, and then that's a whole other situation that you got to go to as far as legal measure.
Yeah, there are some folks who are creating fake quick claims where they are pretending to be a notary person, because I have reported some houses that had fake quick claim deeds plenty of times, and I found out about it by going through the Michigan notary search. So there are folks who are pretending to be a notary.
Yeah, and like I said, at the end of the day, that's fraud. So if you didn't take part in it and you are the owner, you're not held responsible for that situation. Unfortunately, if a lender went through and gave them a loan on it, the lender just has to eat that at the end of the day. Yes, ma'am.
I have a suggestion for if you are pertaining to property in Wayne County, they have it where you can do a search and you can have it automatically sent to you if your name comes up or your property comes up and something is filed. So it'll let you know if something pops up.
I had one question. So with the quick claim deed, can you get a title search done before you complete the quick claim deed transfer?
Yeah, I have investors that I work with, a lot of them, because like I said, when they're buying from the auction, they get those on quick claim deeds.
Okay.
So they'll come to me and say, hey, Leon, can you just run a title search and do a FOIL for me on this? Because I'm planning on buying this house at the auction, and I know they're going to give it to me on a quick claim deed. I'm just going to make this investment up front just to make sure everything's good, so I don't have to worry about any issues at the end of it. So yeah, absolutely. You don't have to own a property to get a title search done.
Oh,
You can get a title search done on any property. Yeah. I mean, to be honest with you, you can technically go down to the courthouse and research it yourself if you want. I mean, that might take some time, but the reason why I'm saying you can get it done on any house is because it's just public records. These are all, it's not like it's private or anything, these are literally all just public records. But any other questions on quitclaim deeds? Okay. All right, tangible title. So tangible title is when a property ownership is unclear or disputed. There's a few reasons for potential having to go through a tangible title. First one is incomplete documentation. So this would be where maybe proper paperwork wasn't filed in the event of somebody may have passed away and just didn't get it done correctly. Second one could be errors. So most of the time when it comes to errors, they're typically grammatical. Either somebody's name is spelled wrong or something was slightly off. There was a situation actually where a lady was looking to buy it in her LLC, and she thought she bought it in her LLC, but her name is actually the name of her LLC. So Jane Doe is her name, and her LLC is Jane Doe LLC. But there was a mistake as far as it being just in her personal name versus it was meant to be in her LLC. So stuff like that sometimes happens, but that's in the instance when it comes to error. And then another one is inherited issues and lack of proper estate planning. So this is just situations where, mom and dad passed away, son, and sister or brother are arguing over the situation. If you put in things like ladybird deeds or trust, you'll be able to get those situations settled a lot quicker without having to deal with those type of things. Issues because of that, because of tangible titles. It limits your ability to sell. Again, if you don't have rights to the property, you won't be able to sell the property. So that has to get situated before you're able to do that. It can prevent you from refinancing. Again, the lender is going to want to make sure that the one that they're giving to is the person who actually owns the property. And if they find out that there's an issue with their ownership or that you don't actually have ownership with it, that may prevent them from giving you the refinance. And also to obtain insurance, homeowner's insurance. The homeowner's insurance company is going to obviously issue the policy based on who actually owns the home. And again, if there's ever an issue or a question of whether or not you have ownership, that can prevent you from getting a homeowner's insurance policy. And ways to correct tangible title, you can do conveyance. So this is basically a legal document that fixes errors on the deed. You're not actually changing the deed, you're just more amending any type of errors that potentially come up when it comes to it. You can do affidavits. Basically, that's a written statement of facts that's sworn and signed by notary, just stating that the information that's listed is correct, and that's an option that you go through. And another one that you can go through is quiet title, and I'm pretty sure Attorney Gianna will probably speak a little bit more in regards to that. But basically, what quiet title action is you're going to sue anybody who claims to have an interest in the property and go through the court proceedings to do that, to verify that you are the person that actually has the rights to the property. So that's what quiet title is. So,
what's an example of a correction conveyance?
let's say like, let's say, again, going back to that LLC situation, there might be just, the name was misspelled wrong or something like that. Like I said, it's usually grammatical is when it comes down to, but that's the example I used where I said her name is Jane Doe, but she meant to buy it in Jane Doe LLC, but it got put into just her name, Jane Doe. Something like that would be conveyance as far as that goes. Any other questions? All right, well, if you guys have any other questions,
I said to you earlier that this is a tremendously valuable program, a tremendous resource provided by the NAACP. And I also said to you earlier that it's important that you understand who makes these opportunities possible for you? Because they don't just happen by themselves. So we have a president who has joined us this morning, and I'd like to ask President Dr. Wendell to come forward and please just say a few words. Because part of the reason that you're here, able to be here, and able to get this knowledge is because of him. Amen.
Good morning to all of you, and just very briefly, let me thank the counselors, advisors who were here to give up their time to express to you from their profession how you can assist yourself, your family, and your community. As Chula indicated, this is a very important part of what we do. NAACP has many venues by which we connect with the community. Everybody doesn't know about this. We would, that everybody does. And when you leave here, tell people about it. Because we wanted, this ain't no secret. We ain't trying to keep this a secret. We want people to come and to take advantage of this excellent information and knowledge free. And it's free to you. But the people that do this in terms of the professionals, they're paying you with their time because to get some of this information, people pay for this. And so we thank you for being here and sharing it with the world. But this is a very important time in our nation and our country. I ain't got to tell y'all what's going on. You already know what's going on. This is just one aspect of it. We have this information going out. We have our regular community meetings on the 4th Thursday of each month at our branch, 8222nd. We ask that you might attend, share that information at 6 o'clock on the 4th Thursday. You can go to our website, NAACP.org, get all this information. At any time, we have our AXO program, Agricultural, Technological, Scientific Olympics, bring students together from all across the country to compete and complement each other in the arts, sciences, music, dance, culinary arts, all of that, everything that we're involved in. We want our children to be involved in, young people, young leaders. So that's a part of it. And we also meet behind the scenes with our legislators on policies and programs that are going to impact all of us. All these policies that's coming out of Washington, these executive orders, this bogus stuff that this man is doing, it's going to affect us right here, right between the eyes. They're declaring certain nonprofits and organizations as anti-American and terrorists. We wouldn't be surprised if they declared the NAACP as a terrorist organization because of what we advocate for, freedom, democracy, and equity. They don't like that. That's what George Crockett advocated for. When we were doing this, we wanted to come up with a name, an individual that reflected what we would reflect. And it came up with George Crockett. George Crockett, whom his colleagues called the Judge. He integrated the National Bar Association, one of the first blacks there. He was a lawyer who represented Coleman Young and others during the McCarthy period, when the McCarthy period, like this period, were locking up people because they were accusing them of being communists. George Crockett was the lawyer for Coleman and others, and people hated him as a result of him doing that. He later ran and became a judge. In fact, when he was a lawyer doing that, they got him off. He received death threats, all of that, because he dared to challenge the system. He later on ran for judge in the old, we call it Recorder's Court. It's now the 36th District Court, but it was a Recorder's Court. And there was a big case, big issue, 1969, called the New Bethel Baptist Church. Anybody remember that here? I know some of y'all too young to remember that.
Read about it.
Read about it. Berlin, I know you didn't know about that. You were too young at that time. So I know that many, but that was an issue that kind of tore at the very spirit of the community. What happened, there was a night in which the Republic of New Africa held a meeting at the New Bethel Baptist Church on the church pastored by C.L. Franklin, Aretha's dad, and now Robert Smith. There was a shooting. A police officer was killed. The police raided the church, shot it up. The people inside, 150 people were arrested, including young people, children, and they were taken to jail. The pastor called George Crockett to intercede and to deal with this situation. So Crockett went to the police station where they were holding the people. And he released, because there was really no evidence, to hold them, 130 of them. And the rest were maintained, but he let 130 people go. Now these were white police officers, all that shot the church up. You can imagine how they felt when Crockett, based upon a lack of evidence and information, let these people go. Mass arrest, you don't know what you got here. So y'all going home, go back home. You ain't done nothing until y'all can prove something. Then these people are free to go home. All hell broke out. White community hated it, the black community loved it because it reflected justice in our community. And so later on, as he ran for judge again, they would have socket to Crockett bumper stickers. Socket to Crockett, the DPOA, the Detroit Police Officers Association, which many of us believe was a terrorist organization. They've changed somewhat. They got a black president now. And you got more black police officers on the force thanks to the NAACP and others, and Coleman Young and others. We advocated for more black police officers. Not to do the same damn thing white officers were doing, but hopefully you would bring a different sensitivity to the table. Some of these might be your sons and daughters and nieces and nephews and mamas and daddies, your neighbors. And so community policing was the type of policing that we advocated. And Coleman brought a lot of that in. We had stress back then. I know some of y'all are too young to remember stress.
I read about it.
Stress was an acronym for Stop the Robberies, Enjoy Safe Streets. Stress was killing people. They was like ICE is today. They were planting weapons in the hands of black men. They killed about 19 or 20 black men, people. They shot up a Wayne County deputy's home. Him and his friends were having a bid whist party. You know, y'all know we play bid whist. And so they shot the house up. Deputy sheriffs, not doing anything but planting cars, but they shot the house up. This was the era in which George Crockett ascended. He later on went to Congress, replacing Charles Diggs as the 13th Congressional District Congressman, and he was successful in that, and he leaves a legacy of justice and dignity for our community. We need more George Crockett's today. But thank God there are some judges who are holding the line against this devil that's in the White House. They are holding the line and doing what justice requires. So I just wanted you to understand the spirit of which this is. It's named after a man who believed in what we believe, and we believe in what he believed in. And so it's a way of continuing his legacy, but also the legacy of the NAACP and what we do. If you're not a member of the NAACP, I encourage you to join. It ain't but $30 a year. Y'all want to spend $30 when you go to the corner store. Isn't that something? $30 a year for an organization that is as critical as this. It ought to be one of the top things on your things to do, things I must do list. You and your family will be a part of this organization. And so we just want you to be made aware of that. You know, I don't know what the future holds, but I do know who holds the future. As people of God, we cannot be afraid. My message in church tomorrow is be strong and courageous. Be strong and courageous. You ain't going to church and come to fellowship. But not that ain't no church program, I'm just saying. It just fits, Richard, I'm sorry. What can I say? But the Methodist talks about Peter. So he said it's only $250. I thought $2.50. It ain't $50. Well, see, you can come to our church free. It ain't no but we do want you to bring some tithes. But it's free. And simple. But y'all know freedom ain't free. Freedom ain't free. We got to pay for our freedom through our time, our talents, and our times. And so I thank you for giving me this presidential moment. I thank those who come out, and may you be blessed with what you will achieve and receive from this. And once you get it, share it with somebody else so they can be blessed. We have some other Crockett law sessions coming up, which I'm sure they'll mention to you at the end of this, and you invite them to participate in the law session.
All right.
Now you can see why he's been, I believe, the longest serving president of the Detroit branch.
Lord have mercy.
30 years, and still kicking, still moving, still leading.
And I don't get paid.
Hello.
But so don't pay.
That's it.
Thank y'all.
Thank you.
Well, it is my pleasure to introduce an attorney who comes to us, I think, every year. Pretty much for the last, however long we've been doing it. You see this gray I got here is my beard, my age. Janine Crump Gibson. Now, she is a very passionate, powerful attorney in our area, co-founder of the Great Lakes Legal Group. And I remember, man, it's been probably, at least 15 years since she founded that. I remember when it came out, you know, there weren't a lot of real estate business firms that were black owned. You know, you have individual solos, but this was an actual firm with, you know, which I remember the commercials, and it was, you know, I had a lot of pride in the fact that, you know, it was really introducing itself to the community in that way. And since then, Great Lakes Legal Group has been serving clients throughout Michigan, federal courts. She does works with families on preparation of court, estate planning issues, legal issues, estate administration. She serves at the Faculty Institute for Continuing Legal Education, dealing with probate, estate planning, business, nonprofit. She's a legal analyst on Fox 2 News, The Noon, a speaker, published author, and has been featured in Forbes, Essence, and Black Enterprise magazine. So without further ado, why don't we bring up to the stage of Janine Crump Gibson. Thank you.
We're going to take it anyway. Good morning or afternoon. Where are we at?
Morning.
We still in morning. Good morning, everyone. I I'm so excited to be here. Part of what NAACP does, which is so important, you heard about the fight, the advocacy, but providing these forms for knowledge are just as important, right? The people perish for lack of knowledge. So I'm so glad that we've been participating, and as Attorney Mack said, I can't remember for how long, but both my co-founder and I, you'll hear from her after lunch, are very passionate about community education, right? We're lawyers for profit, we got bills, but at the same time, we think that it's very important to educate our community because we don't know what we don't know, right? So today we will discuss some things that we can do to avoid some of the issues that Mr. Mallett talked about with tangled titles, things of that sort. You might remember on his slide, he said one of the causes of tangled titles is lack of estate planning, right? So that's what we're going to talk about today. We're going to do a crash course on wills and trusts and talk about deeds. And let's see if I can go, oh, look at me. I'm working on it. Getting it. Okay, so what is probate? Probate often refers to the administration of a deceased person's estate, someone that has passed away, regardless of testacy. Testacy is just $1 million word for whether you passed away with a will or without a will. Passed away testate if you have a will, intestate if you don't have a will. Probate is required when a person dies. Did I do that? Y'all bear with me. Bear with me. Also, older than I look, I get my roots done on a regular basis. Okay, so the rule of thumb, and this is important for everyone to understand. I'm going to repeat it 3 times because that's how important it is. The rule of thumb in Michigan is if you pass away with property in your name alone, it has to go to probate. If you pass away with property in your name alone, it has to go to probate. And one more time, if you pass away with property in your name alone, it has to go to probate. This is a bank account. This is a E-Trade account. This is a house. Anything that you own that's in your name alone when you pass away, I don't care what you have, it has to go to probate court. You can ask me every exception, and I'll be here for a while. We can talk it through. You can ask me every exception, but there's not one. So that's why it's so important to plan, right? Probate also is commenced for guardianship and conservatorship matters. So if you become unable to handle your own affairs and don't have the proper documents in place, that's handled in probate court, but today's session is focusing on wills and trusts. So, testacy versus intestacy, I just gave you all the breakdown, but testate is with the will. It's your property gets distributed in accordance with what your will says, which is great. It's a start, right? But that doesn't necessarily mean we avoid probate court, and we'll talk about that. Intestate means without a will. If you pass away intestate, that means your property is going to pass to who the state says it passes to, right? So if your lineage is Bubba and Smokey and you don't want your property to go to Bubba and Smokey, that's too bad, because if you get up out of here and you don't have a will, Bubba and Smokey are inheriting your property. There are also no exceptions to that unless the family agrees. So, what types of property must be probated after you pass away? We talked about the rule of thumb, but we're going to get into it a little bit more. So if you have a bank account or a house, right, or anything that you have, and it's only in your name alone, I mean it has no joint owner, whether it's your spouse, a child, a sibling, if it's in your name alone and it doesn't have a beneficiary on it, it has to go through the probate process. Non-probate property, jointly owned, typically is going to pass to whoever the other owner is when something happens to you. There are exceptions in real estate that we'll talk about. Property that you put in a trust, and we're going to talk about trust today, those avoid probate court. If you have annuities, life insurance, and retirement benefits with a beneficiary on it, it's going to go to who the beneficiary is, right? That passes by contract. There are very few instances when we can challenge that. And where our people get in trouble is they put somebody on the life insurance policy and they trust them, right? Or they think their will can override it and they think their property is going to pass to all their family members, and it doesn't happen that way. So we'll discuss how we can avoid that. These are your 3 basic post-death estate planning tools. So when you do them, you have to have sound mind. That's the most important thing. People call our office all the time. Mama has advanced dementia. She's in renal failure. She's in hospice. we're not expecting her to make it through the end of the week. She can't even talk. What do we do? Pray. You know what I mean? Like, we can't do nothing, we can't do this. And those are how these things get set aside. Folks will have mama sign this document, she don't even know what day it is, right? So she doesn't understand what she did, and that's what turns into these long probate battles. It happens all the time. So you have a will, you have a trust, and you have a ladybird deed, and we're gonna break down each one. The will, so it's just an instruction sheet, okay? Wills do not avoid probate court, they don't. So anytime I hear folks pushing out there, get your will done, get your will done, that's great. But of course it makes me cringe, somebody that's been doing probate work for 16 years, because I know it doesn't avoid it. And the heartbreak that I have to see on people's faces when they come in and go, well, I don't understand why I have to go. Dad had a will, my husband had a will, so-and-so had a will. And I'm like, it's great that it exists, right? Because it tells us what to do, but it won't avoid court. So it does do a few things. It establishes who the personal representative of your estate will be. The old school term is executor. We use personal representative or PR now. That's the new age term. So who the PR of your estate will be, that's just the point person who's legally responsible for making sure your debts are paid and your property goes to who either the state law says or your will says. You also, if you have minor children, that would be who nominated the guardian or conservator. So the human being that took custody of minor kids, conservator manages money. So who would manage money for them? Again, your will does not avoid probate court, and it does not affect the transfer of assets that have joint owners or beneficiary designations. So if mama has a life insurance policy and she left her oldest son on it because he was the oldest and she thought he was the most responsible, but she really has 4 kids, right? So mama goes and either has a will done, she has somebody print her off something online, whatever she does, she signs her will and she says she wants all her property to go to all 4 of her kids. The will can do nothing about that life insurance policy. All that money is going to go to that oldest child, and if he does not want to share with his siblings, he is not legally obligated to do so. Frankly, he don't even have to pay to bury mama. Right. Have had those come to the office before. I had a family some years ago, one of the kids called, dad passed away unexpectedly, and one of the youngest daughter was left on the policy. She was in and out with dad. She was mad because for the last time she went to him for some money for some new venture. She always had something going on. And he didn't give her the money and she got mad. So she hadn't been talking to him. So dad passes away. They get him over to Pye Funeral Home. And they figure out the insurance policy is in her, she's a beneficiary. So she gets over and she didn't have the same mom as the 3 older children. She gets in there, they're sitting around, and she goes, oh, well, I don't want to use Pye. So unless we move dad to whatever other funeral home here, I'm not paying for it. That girl walked clean up out of OH Pye, didn't look back, and got her policy cashed, and probably spent it within a year. She's probably grown now. That goes to show you what happens when you leave the decision to trust people, right? Or if you just, do a will real quick, not understanding that those are the types of things that can happen. I always say, even if you think you can't afford a lawyer, at least do a consultation, right? So that you'll know. So most folks will come in our office and I'll go, oh, here's my will. And I'll go, okay, let's talk about your accounts, who's on them. And they are shocked when they hear, well, this will can't do anything about that, right? Okay, let's talk about a trust. So legally, all it is a contract, right? But from a practical standpoint, I compare a trust to a flower vase. So imagine that all of your assets are flowers. Your house is a flower, your bank accounts are flowers, your insurance policies are flowers, your retirement policies are flowers, your business interests are flowers. As long as those flowers make it to the vase, they can avoid probate court. So that's either putting the trust as a beneficiary on something instead of Bubba, right? So that it'll go to the trust. Making sure you put your property in the trust instead of just adding somebody on the quitclaim deed. When we put things in the flower vase, they can pass how the trust says without the need for probate court. So I tell most people, there's no way that you can 100% avoid probate court. Unfortunately, human beings do what human beings do. So sometimes you may put the paperwork in place, but you got that one relative that's always been a problem, so you end up there anyway. Or you may forget to put an asset in the trust later on, right? So things happen, you can end up there, but this is like the most surefire way, right? If you had to put your eggs in a basket, that you can avoid probate court. So the grantor or the settler is just the person that sets the trust up, that's the creator. Right? The trustee is the person that carries out the terms of the trust. Most people, when they're living, they're their own settlers because the trust is still for your benefit while you're still here. It does not become for the benefit of whoever you name until after you're gone. And those are the beneficiaries. Those are the people that receive the benefits from the trust. So whether that's putting the NAACP to get a little money in your trust, y'all are welcome. The church, your relatives, whoever it is, but there may be causes that you care about and you want to make sure they got a little something when you leave. You can get as creative as you want with your trust. You can control when people get stuff. You can hold it in there, say, hey, they got to be working, they got to have a job. You can literally continue to control things long after you're gone with the trust. That's the benefit of it. One of the many. Now, there are two types of trust, two categories. There are the living trust and there's the testamentary trust. I don't even like talking about testamentary trust anymore because they don't avoid probate court, but this is the Crockett Law School, so I'm supposed to educate you all on the law. So we will talk about it, and then I'm going to tell you, forget about the right side of the screen. So for your living trust, that's what I just talked about, that flower vase, right? So you put the flowers in the vase and you make sure they avoid court. Under that category, there are revocable trust and irrevocable trust. Revocable trust you can change at any given time that you want, as long as you have that sound mind that we talked about, right? I think the most changes I have on record was a great-grandmother who changed her trust 8 times. And it was because she would get mad at her oldest grandson. And then when she wasn't mad at him anymore, she'd come back down, put him back on. But she was of sound mind when she did it, right? So she had that right to do. Irrevocable trusts are different. Once you set them up, it is nearly impossible to change them. Now, they have great benefits, right? They avoid creditors, they reduce your tax liability if that's going to be an issue for you. They are good for if you have beneficiaries or you have special needs and for Medicaid planning, right? So they have some benefits to them, but if you have to be able to access an asset, right, you can't set up an irrevocable trust and put it in it. If your house still has a mortgage on it or you still want the flexibility to pull equity out of it, you can't put it in an irrevocable trust. Once you put it in an irrevocable trust, you are relinquishing all control and ownership. So you can't go, oh man, I needed money for this. I need to pull money. It's over at that point, right? So most of us have revocable trust. As money grows, and I'm speaking that over everybody in this room. So as your money grows, you may have both. So there are some folks who still have a revocable trust, but maybe they inherited some money, got some money from somewhere, and they were able to put that in investment vehicles and put that in an irrevocable trust. So some folks have both. It really just depends on you. The name of the game with estate planning is, it's like your fingerprint, right? Everybody has their own unique fingerprint. You're going to have your own unique plan. So it's going to be based on you, your people, what you have, and what you want to do. Now, for a testamentary trust, that's created within a will, right? That instruction sheet that we talked about that does not avoid probate court. It operates the same way as a living trust, when it comes into play, but again, it has to be administered through a court. Why would you do such a thing? Right. People typically, so I'm like, yeah, why are we even talking? I told you to forget about the right side of the screen. But if people couldn't fund it right now, all funding means is putting the flower in the vase. So if they couldn't set it up, the old saying, I'm worth more dead than alive, so maybe all you had was something that would only come to fruition after you passed away. So in the mind frame, you're like, okay, well, I want to control what happens with the money, but I don't have anything to put in the trust right now. I just don't have it. That's where a testamentary trust will come in a lot, but again, there are ways to get around that. I discourage them because, again, we have to go to probate court for them. I have a client now, she's originally, she's passed away. She was from Canada originally, but moved to Detroit and lived here for 50 years before she passed. I didn't do her original will, and I know I wouldn't have, because it had testamentary trust in it, right? So she has all these assets, and she's got all these relatives here in Michigan, she's got them in Canada, she's got them in New York, she's got them everywhere. And one of those beneficiaries, who's a niece of hers, has special needs and is in Canada. Y'all can understand how complicated this is, right? We even had to hire lawyers in Canada. We had to do all sorts of things jumping back and forth. So even though her wishes were clear, so there are some charities that she's giving some money to, and again, her family, but all this is tied up first in Wayne County probate because she lived in Detroit. And then after we get done here, she has to deal with Manitoba County in Canada. So how much money is that off the top? And that's taken away from what she's going to be able to leave for her loved ones. Now, everybody doesn't have assets to justify a trust, right? So let's say I have a widow that's 90. She has one adult son that's 70. She only has her house that's been paid off for some years, a checking account, and a burial policy. I'm not going to do a trust for her, right? It doesn't make sense to have her pay that extra money and do this complicated tool. All she wants is for her son to have a house when something happens to her. So what we would do for her is we would insert a little bit of ghetto estate planning. Let me tell you what that is. A little street estate planning because you have one game with that. So we would make sure that her son was the beneficiary or the transfer on death on her bank account, right? We would probably recommend leaving a contingent just in case something happens to her son. So if her son has a child that's an adult, we'd say leave them after in case something happens to the son. And then the same on that burial policy that she has, so somebody can at least make sure to move forward and be able to bury her. And then for the house, we would do a ladybird deed. So ladybird deeds only exist in 5 states right now. And so if you go talking to your relatives in Alabama and Georgia, they don't have them. So don't tell them to go run off and call a lawyer on Monday and get a ladybird deed because they're going to get their feelings hurt. There are options for them, just not this. So the beauty of a ladybird is you keep the property in your name while you're still here, and you can do whatever you want with it. You can mortgage it 8 times, you can sell it, you can give it away, you can rent it. But if it's still in your name alone when you pass away, it'll automatically go to who you name on the deed. So it's kind of like leaving a beneficiary on a house, right? So this is a way that we can avoid probate court for folks that don't need trust. Or maybe for folks that do have a trust, but maybe they don't want the property to go into it until after, something happens to them. This is what helps us avoid those quitclaim deeds that cause problems. And we heard Leon talk about it earlier, what happens with quitclaim. People just play musical houses with quitclaim deeds all the time that create all sorts of issues. But some folks will do. I did a seminar last week and a woman asked me, well, I think she had 8 kids. And she left her oldest daughter on everything, and then she had added her on the deed to the house, and she said, well, I want, all my kids to be able to get the house. I said, well, unfortunately, if your daughter doesn't agree with that, she doesn't have to do it. When she added her daughter to the quitclaim now, even if mom wants to take that back, the daughter has to agree to take it back. Once you add somebody to your house on a quitclaim deed, they have equal rights to you as owner, assuming you own the house. We talked about that earlier. So assuming you are an honest human who has title to your home, if you add someone now, whoever you add, they have to sign off if you want to sell it. They have to sign off if you want to pull equity out, right? So you have equal rights with somebody that hasn't put a dime in your house. I don't care how much you love them. They don't take care of the taxes, the insurance, the maintenance. When anything goes wrong, they are nowhere to be found, yet they have equal rights to your house, and they get to determine whether they stay on the deed or not, right? The other thing you do with quitclaim deeds is take on people's problems. So if somebody files for bankruptcy, if they get hit and they're underinsured, if they go through a divorce, if they get sued in a lawsuit, and somebody is looking at what we call their accountable assets, stuff that they have that could pay, guess what's on that list? Your house that you lay your head in, right? So we want to avoid that. That's quitclaim deeds are also ghetto estate planning that I do not recommend. I indulge in a little ghetto estate planning from time to time, but not with quitclaim deeds. But this is a way that we can avoid it so you can still have full control of your house when you're here, but we can avoid probate court. What do you all think the number one asset is that we're in probate court for? Y'all are scholars. Get the ceremony, get the graduation cap. So yes, houses, that's the number one reason we are in probate court. Right after that are bank accounts, because the bank will not tell you when you open the account, put a beneficiary. They don't operate like the life insurance companies and the retirement accounts. So people don't know what they don't know, right? You don't assume, the last thing you're tending to think about is your bank account. So properties first, bank accounts next, but these are ways that we can avoid it. So we encourage you, again, whether you need a Lady Bird deed and a will or a trust, that's going to depend on you. So we recommend, even if you don't want to hire a lawyer for the full process, again, at least have a consult. Some folks come to us thinking they have it all together, and something's together, but it's not what they want, right? Or when they see in place and you start asking questions and you go, well, actually, as it stands now, this is what would happen, not what you think. So arm yourself with the knowledge at minimum, even if you're not going to make some changes, at least know, right, what you're walking into. Probate court is special, to say the least. It is lengthy, it is stressful, it is time consuming, and in Wayne County, it's the busiest probate court in the state and one of the busiest in the country. Wow. So every time we think it's an emergency, it's not an emergency as far as they're concerned. It's you and 1,000 other of you that have the exact same issue that's trying to get on the judge's docket, right? And when you're dealing with that high volume of things, right, things are going to slip through the cracks. There are going to be delays. There are going to be things that you can't do. We'll open up estates and folks will go, well, I need access to so-and-so, mama's account because the mortgage is due. How many people think the court would consider that an emergency? No. Absolutely not. They don't even consider foreclosures an emergency. They don't. Why? Because there's a redemption period. Right? So if it's sometimes, depending on the clerk, the judge today, maybe you can slide up in there to avoid a foreclosure. But imagine how many homes are in probate that are subject to foreclosure. It's you and 500 other people trying to get on the docket, right? So you can imagine how this can cause delays. In Michigan, all estates have to be open for 5 months by law, and that's to allow for a 4-month creditors period. But rarely does that happen, right? Because there are all these things that are going on. Then let's say somebody passes away and then leaves 2 or more relatives, and they can't decide if they want to sell the house or if both of them want to take the house. They didn't get along when they were kids. They are not going to get along when you leave here. I promise you. It's going to get worse. So you just don't want to leave those things to chance, right? So it's much better. Leon talked about earlier with like getting that title search done to avoid having a quiet title and file all these things in court later on. This is exactly the purpose of estate planning. It's a controlled amount that you can spend now to avoid your relatives spending thousands and thousands of dollars, wasting time, right? Potentially, the court may sell off assets that you wanted to stay in the family because your relatives can't agree, and you don't want that to happen at all. Even if there's an only child, folks will ask me, oh, well, I only have one daughter. She'll still have to go through the probate process. Maybe she's not fighting with someone, but she'll still have to go through the probate process, and it's something that you want to avoid. We have some phenomenal judges on the Wayne County probate bench, but I say that I used to say about 10 years ago that probate court was a step above criminal court. Yes. I lied. Yes. It's worse. Yes, it is worse. We see people go to jail from probate court. They get judgments against them. There have been physical fighting. I had a probate court trial a couple weeks ago in another county, and we had to end up having 3-4 sheriffs there with us for protection because my client's brother said that if he came to Michigan for this trial, he wasn't going to leave. He was going to be in a casket. And then threaten the whole family, right? Wow. I mean, when I say it is like the Tyler Perry movie times 12 in probate court, that's exactly what it is. Wow. And plus all your business is out there. Exactly. We don't want Wayne County to know all your stuff, right? We're private people, so we want to try to control this stuff so it doesn't make it to the courthouse in front of everyone. As Leon said, the title stuff, all probate actions are public. I can go pull Aretha Franklin stuff right now and tell you exactly what's going on. My law partner is here. I do this all the time. Y'all remember when her estate first opened and the cameras were up at Oakland County Probate Court on a regular basis? We were getting calls because this one was so nosy. She would just be up in there like, yeah, is your partner on the Aretha Franklin case? I'm like, no. And she's up in the courtroom, she's looking at the flipping through the pages like, girl, did you know her niece? I'm like, and that's Aretha, right? But just, and she was. It took over her. So it's a spirit that got a hold of her. She just had to know. Like, what isn't Ayana do back at the office? No, she was up at the courthouse. But the point is, whether you're Aretha or someone, it's the same thing. Anybody can go down and get your probate file. Exactly. Literally anybody. Anybody can listen in on probate proceedings and say, yeah, I saw Miss Ethel pass. I know her kids was a mess. Let me log in and see what's going on here. Right? We don't want that to happen. So invest in the time that you need to get your plan done so that we can avoid that. So that is our information. I would love to take questions right now. If I haven't scared y'all to stories.
Okay. If a person passed away in years before their death, and we talked earlier, so they don't have any property, no bank accounts, just in their names. They established because of the beneficiaries on all the accounts, bank accounts. How can they take my house?
So here's what I will say in general. There's nothing that you can do to 100% avoid court because people will do what people do every time, right? The only thing that you can do is set things up so that if it got to court, you could be best protected. So one of the reasons why I say it's always good to work with a lawyer, you could theoretically do the exact same paperwork that a lawyer could do, but when a client comes in our office, and especially if it's an older client or someone with health issues, we're taking very specific notes so that if anybody ever has to call us to testify, we can say, this was Ms. Smith on this day. She was alert, she was oriented, we asked her who her children were, out of the view of anybody. So we kick the kids out the room, the grandkids, the nephew, the everything, because we want to make sure that people are doing things on their own free will and nobody's exercising, any sort of undue influence over them. Right, so we'll keep that, and sometimes, again, you can't avoid. Once the other relatives find out about the documents or what went on, or they understand, oh, that meant that she got the house, they can file anything in court to try to challenge it, right? But if you have your ducks in a row, and there are notes that you can say, okay, we have this, right? There was this independent party, the notary wasn't cousin Susie, or somebody wrong. A lot of folks don't know you can't have people that are related to you notarizing your documents, right? That's in the Notary Act. So these are the places where people get in trouble or picking witnesses and documents that aren't wrong. So I can't say it's 100%, but the best thing to do if you have it done, at least with a third-party professional, that helps because that goes a long way, right? So if somebody's calling a practicing attorney that's been doing the states for 20 years and they have a process and they come forward, and then that along with a medical professional and other people testify, Susie was fine in 2015 when she did this. There wasn't an issue here. She understood X, she did Y, she did Z, but obviously imagine how long that can take and how much drama it can take. And if a decision is made, then you might have to appeal it. So someone can always challenge what you do. I don't want you to ever think that there's something that you can do to avoid that because again, humans will human. I use human as a verb too, every single time. So they will human, but all you can do is try to set things up so that if it does happen, right? So when people call our offices, that's why we don't play games with people. Oh, well, mama has some good days, some bad days with dementia, and we'll tell them, you are setting yourself up for a challenge later on, right? So if this is this one relative, the one that's normally with mom or living with mom relies on them for caregiving, they take her to all the doctor's appointments, and that's the one shuffling mom up to the office to get the documents done. You can understand how that can look to a court, right, and be an issue later on. So we want to try to make sure that our relatives are doing things when they're in their sound mind, and if you have a third-party professional that specializes in this. And I'm going to repeat that again, because if it's the DUI lawyer, you don't go to him for your estate plans, we can't do it. You would not go to the cardiologist to deliver your baby, so do not go to the DUI lawyer to do your estate plan. right? But we have specialties for a reason, because sometimes, yeah, can they get the piece of paper down? Sure, put your wishes down, but they may not understand the implications, right? In terms of probate, so that's all I can say, is try to plan.
Can we operate with just a trust instead of a will?
Yeah, so you can.
Create the will.
Yeah.
We would have to file it with the court, whereas probate, but we don't wanna go to probate, we need to operate with the trust.
Correct. So how it works is, when you have a will, you don't necessarily have a trust. When you have a trust, you will still have a will, but let me explain why. So to your point, yes, your trust is gonna be your lead document that says what happens with your stuff. And that's why it's so important to make sure we actually put the things in the trust. Folks will go and either print one offline or have one done and then never do the work to get their assets in the trust. All that stuff is going to probate if you leave it in your name alone, right? So what may happen over the years, we may set a trust up, somebody may change all their beneficiaries to the trust, you know, change accounts over to be in the name of the trust, put the house in the trust, but then maybe they inherit something or something else comes to them and they forget about it. So when they pass away, it's in their name alone, right? And we remember the rule of thumb, right? If you pass away and it's in your name alone, it doesn't matter if you have a trust, it has to go to probate first. So what a will does when you have a trust, it's called a pour over will. It will take whatever got left out of the trust and pour it over in there. So I'll give you all an example of why we still want a will when we have a trust, just as that safety net. I had a grandmother about 10 years ago. She passed away right before her 100th birthday. So she was a great grandmother. Granny was 99 and 10 months, okay? So Granny, over the years, was very smart with her money. So she saved, she invested. And by the time she passed away, Granny probably had about a $3 million estate, right? So mostly everything was in her trust. Most of all her flowers were in that vase, except for some savings bonds. So Granny had about $150,000 in savings bonds. And she had her kids as the beneficiary on those bonds, the payable on death. That's what a payable on death is, a beneficiary. But the unthinkable happened. September, her son died of pancreatic cancer. Thanksgiving weekend, daughter slipped into a diabetic coma and died. And on New Year's Eve, the last daughter died. She had Alzheimer's. Whoever expects something like that to happen, right? So unfortunately, when all her kids passed away, that left assets in her name alone with no living beneficiaries, right? Had her trust been the beneficiary on those bonds, they would have gone to the trust, and then, great, we wouldn't have had to go to probate court. So unfortunately, we had to open up an estate, because ain't nobody leaving $150,000 on the floor, right? So we went and opened up that estate, but because she had the pour-over will, it took those bonds, poured it over into the trust, and now her grandchildren and great-grandchildren are getting the money how the trust says. So the pour-over will operates as a safety net in case anything gets left out of the trust. But that trust is our lead document, and we don't have to file that with the court. We don't want to, because we want the court out of our business.
Right.
Here, and then I'm coming here.
Is there a scenario where you have your documentation and the attorney files your will with probate so that you never have to go to probate?
The filing of the will with the court does not avoid you going to the court. The only thing that avoids you going to the court is property not being in your name alone. So wills get filed with the court typically so that if it gets lost or destroyed, at least the court has a copy, right? So if somebody prepares one, it's up to you. Are you required to file it with the court? No. But think about over the years, if somebody moves or there's a flood or whatever happens and the document gets destroyed, right? If it's not on file somewhere official, you can't prove a negative. You can't say, I know grandma had a will. They're going to be like, okay, where's it at, right? So the purpose in filing it with the court really is just for safekeeping. That's why you file it with the court. But some folks don't ever even have to go because they didn't leave property in their name alone. Maybe they did that will, but they left beneficiaries on everything, and that property is going to pass to the beneficiaries. So that's why you file with the court. It's really for safekeeping.
Thank
Mm-hmm.
you.
Two questions. The first one, I'm on the joint tenants with full rights of survivorship.
Mm-hmm.
It's 3 of us.
Mm-hmm.
So if 2 people pass away or one person pass away, the third person, does it go to them or does it go to their family?
I'm glad you asked this. I'm very difference between joint tenants with full rights of survivorship versus just joint tenants, right? Those specific words have to be on the deed, full rights of survivorship. And if something happens to one joint owner, the surviving owners own the property. So if it's 3 of you all, something happens to one, the surviving 2 own it. And then if something happens to one more, the lone person ends up owning the property by themselves, right? This is different if there are no rights of survivorship. If there are no rights of survivorship, then that person's heirs at law is who's entitled to that third of the property. So we've had people do their own quitclaim deed, right, with a little street estate planning, do that quitclaim deed, and they added, 3 people, right? But the words full rights of survivorship weren't on the deed. That means they have it as tenants in common. That's what we call it in the law. So that means if something happens to you, then your share is going to your heirs at law. It's not going to the surviving owner. So you all can imagine the problems that will cause. Sometimes we'll go to court, and maybe there were 3 people on the deed, right? And then 2 of them passed away, but they all got 6 kids and 7 kids apiece. So that's now 13 people that own 2/3 of this house.
And if the name isn't on there and you're a tenant, you're just on the street before the paper.
If they want you to be. But you have to go through a process, which my law partner is going to discuss after lunch. But yes, you have to go through a legal process, and that ends up happening a lot. There are rental properties where the owner or owners, right, are going through these title issues. Maybe they inherited it, there was a few people on the deed, and then they're dealing with one of the owners paying rent or something like that. Something happens to that one owner and they pass away. Whoever steps in, if they want that house and they want you out, they can get you out if you're a tenant.
You mentioned that it's 3 of us on a house. If one of the person files for bankruptcy or gets sued, they have rights to the house?
It's not that they have rights to the house. Basically what they're doing is looking for, when someone gets sued, let's say you get to the end, somebody gets a judgment against someone, right? They're gonna look at all of your ability, all your assets to look at your ability to pay. They do creditors exams. And obviously if there's real estate in your name, right, that's something. Now, rarely are they gonna say, I'm going to court and I'm forced to sell this property, right, so that I can get paid. Could they though? Yes, theoretically, right? Or if it's bankruptcy and somebody has, the house is subject to bankruptcy protection, you can also see where those issues come in. So, is it common that someone's gonna come and snatch the house? Maybe, sometimes, not always, but you never know. I had a client who, oh boy. So basically, her business partner had put, they have real estate in the business. Her business partner was married, and he purchased a property for not his wife. Hear me, just stay with me where I'm going here. And so, at the end of the day, what the wife's lawyer was able to do when the wife eventually filed for divorce, he had some legal troubles, yada, yada, yada. They did a full forensic deep dive to figure out everything that man was connected to, which took it back to these properties. So homegirl and her kid, they had to get up out of there. Wow. Okay.
There's a question in the chat. It says, if you have a will and trust and with multiple beneficiaries, one dies, does money go to the heirs or divided now by those that are left?
Wonderful question. Depends on what your document says. So your document, now if it's silent, right, then it can stand to go, to whoever that person's heirs are. But when we draft documents, we walk you through that. You do planning, forward thinking the absolute worst. Like great-grandma that I talked about, where all her kids predeceased her. Even though we don't like to think about it, we plan for it, right? Or what if something happens to these people before the money gets to their hands? Do you want it to go to surviving relatives? Do you want it to go to whoever their heirs are? So your documents would speak to what happens.
I have a quick question. My question to you is, I've seen this a few times, and not even experiencing myself, but how important, because a lot of people and family members buy stuff, they get trusts, they get wills, they know all the information, but they do not take time to explain who the person is next to, the instructions they need to execute any of these documents because you spin around looking at this house, and this one, and it's a lot.
Mhm.
Speak to that a little bit.
Yeah, so we leave it up to our clients on how much they want to involve, you know what I mean, the next person and the next generation. I mean, generally we say this is not like the movies, right? Grandma doesn't pass and everyone comes to the lawyers, all this, around the fireplace. I'm not reading y'all grandma's will near my fireplace. I'm never gonna do it. So you just don't, and then everybody's all surprised, what? I'm guardian? No, like that is not what happens in real life. But to your point though, the danger is what ends up happening when people get all their documents done in secret and then don't talk to folks. What if the person that you nominated doesn't want to do the job? What if they can't handle it, right? So then you're stuck in a lurch because, you know, they look at, it's me? I'm the one that has to do this? I don't want to do that. You know what I mean? So you don't want to the extent that you're comfortable, because some folks may end up on an episode of Snap for 48 hours if they share their documents with people, but you want to talk to whoever you've put in place because you should trust this person, right? When you're handling this business, even though it's personal, it's still business. So you can't make these decisions based on emotion. Oh, that's my oldest kid, you know, he'll be mad if I did. You won't be here, it's okay. You won't have to deal with him being mad at you, right? You don't put him just because he's the oldest. You list whoever you know can do the job and is trustworthy. It has to be those two things. Some folks may be one or not the other. Some folks, you may have that relative, the high off the horse one, went to the best of schools, they got the finance background, so you know they can do the work, but they still late. So we don't want them on our documents, right? Or the other one, you may have Bubba that you know will lay down on a train track for you, but he can't manage a lemonade stand. That is not who we want over our stuff, right? So when we think and we put the right person in place, you don't catch that person by surprise. You tell them, okay, here's what's happening. Some of our clients ask us to meet with, so at their signing meetings, they'll say, hey, can I bring so-and-so, and can you kind of at least explain this? We talk about where to keep documents, certain lists, because granted, you can have the trust drafted, but if there's no comprehensive list of what you have and where your stuff is, people are literally stuck going through mail. I think she got an account at Comerica. I think, you know, so you have to, for a practical standpoint, leave things for where people will be able to find them and give them an idea. A lot of times people pass away and folks have no idea what they have. So lawyers, we got to send out, I mean, there's certain places where you can search for insurance policies now, but sometimes we just have to blindly issue subpoenas to all the banks that operate. And see, shake the trees and see what comes out. There's no master database that exists that you can just go online and find out something that everybody has. So I think that's all I have there. Yes, ma'am. I don't have my distance glasses on, but I can see a little.
You're doing a great job. Thank you so much for the information. Thank you. Another thing too, I would like to add to this, only from experience. If your parents have anything under the bed in the house, or someone like that, have those conversations. They may have them from, you know, of course in the bank and things like that, but sometimes they save them in a mattress.
They
Sometimes
do.
they have them in the closet.
They do.
And you come across, you may not know, the caregivers know.
And they'll take it.
And they'll take it. And they will take it.
Or your family members will take it.
Oh, I ain't even there yet.
Honey.
They'll do it too. And not the ones, so you thought Dante was taking it.
Right.
But Uncle Mr. Who, Rich, he took it.
I gotta steal that one. Uncle Mr. Rich. That's in the next presentation. But you're right. You're absolutely right.
With every documentation in place, and I am the only survivor.
Wow. So that goes to show you the practical side of these things. These documents can only control the assets that come to it, right? So if you know that granddaddy didn't have those conversations, if you have a whole bunch of cash under here or stuck here or all this jewelry, these firearms, because that's been the things, people will go up in that house and clean it out. And we have had families where they haven't even come to pick the body up. They're going through the wallet and they're in the closet ransacking.
And asking.
And asking. So we have those conversations to figure out where's the best place to keep this stuff, right? Where do we safeguard it? Because at the end of the day, you can't probate stolen cash. That Mr. Who is it again?
Mr. Uncle Rich.
Mr. Uncle Rich.
representative, and you spoke on that. One thing about an executor or the representative, they can change whatever they want to change in the will or the trust.
They can.
Yeah, and the problem is, there's nobody that can be accountable. They're not accountable to the courts.
Did you say
They cannot.
What they do.
Nobody, now can they commit fraud? Yes. So everything that we're talking about, yeah, and we deal with it all the time. People will forge signatures, put together fraudulent documents, yes, that happens. If you dealing with frauds, you dealing with frauds.
Yes.
Generally though, nobody can change your estate plan documents but you. That's how it's supposed to go. And theoretically, that's why you have to be on watch, because what will happen often, to your point, is unless somebody puts something in court, there is no court supervision. So let's say you have a trust, right? And you left somebody as trustee, put them over it. Now, if the beneficiaries, that's why they have to watch for things, right? If you ask them for information on what's going on and they're not talking to you, they done block your calls, you pulled up on them at the stoplight, they took off, they're avoiding you. If something starts to seem weird, that's when you come to us. And sometimes we've had to file petitions to put the trust in court, even though it's supposed to be private, because that person wasn't doing the right thing. It's about money. So again, there's gonna be no way that you can control every single thing, but always vet. A lot of people now are third parties, maybe like a bank, a CPA, or a lawyer that may do the administration. Because if you flat out don't have a relative or a close friend that can do both, be trustworthy and do the job, then you may not have somebody in your family, and it may have to be somebody else that does it. Because you're absolutely right, the check and balance can only go so far.
Right.
And you have a question, you had a question, Chewy, or are you telling me time?
I have a question. So after you do those.
Okay, I'm sorry. I'm gonna wear my distance glasses next time. Sorry, I just see hands.
The last two things, personal experience and bank accounts. Beneficiaries are needed for savings and checking accounts if you're at the same bank.
Yes.
True, because I went through it, my mom passed, and she had me as a beneficiary on her checking, but not the savings. So people should always double check to make sure their beneficiaries are separate or the same, but they need to be listed.
Yeah.
And then my question is, I have a Lady Bird deed that I never got recorded, and do they have to be recorded? Because I still want to keep, if I want to put a mortgage on the house, I didn't know if it was recorded, if that would stop me, or if I put my house in a trust, if I wanted to get a mortgage, if that would stop me.
It will not stop you. So two things, if we don't record it with the county, it's not on public record that it exists, right? And the danger is that is if it gets destroyed or lost, right? So that's a danger. You can always record deeds later. That used to be like a whole thing, hold on to it, deliver it, it can, but that works until it doesn't, unless it gets lost or destroyed. When you put property in a trust or do a Lady Bird deed, if you use it, if you do it, whether it's a warranty or a quick claim, and I'll talk about the difference in a second, sometimes what lenders will do will have you deed it back to yourself to get the financing, and then you can just do a quick claim back to your trust or do another Lady Bird. But Lady Birds in and of themselves should not impact your ability to do that, because you're not transferring the property away from yourself. You're doing what we call in the legal term, you're giving yourself a life estate in the property and then adding a beneficiary, but you're not saying it's not mine anymore. So you should be able to. With trust, we do have clients, sometimes if they want to pull money out, we may have to quick claim it back to them, but then come back to us. Because if it never makes it back into the trust and something happens to you, guess where it's going? Probate. There was something else you said that made me think of something else. You said mortgage, quick claim versus warranty. Lady Birds can be either. A Lady Bird deed can be a quick claim or a warranty deed. So what it is an enhanced life estate deed with what we call a power of appointment, right? It can be a quick claim, meaning you're transferring only what you have, subject to whatever lien or encumbrance, or it can be a warranty deed. We can't do a warranty deed as a Lady Bird when you have a mortgage on your property still, right? Because you don't own it free and clear. There's an encumbrance on it. But we can do it as a quick claim and it still will operate how it needs to operate. So Lady Birds can be quick claims or warranties, depending on if you own the property outright. I'm sorry, Chu.
No, I'm sorry. What do you do as a practical matter with that child who is undocumented? And after the death becomes known, or it may even be known before the death. address
Your
it.
death becomes known or their death becomes known?
The dad's death becomes known. I'm sorry, the child becomes known after the dad's death or before,
And the child is undocumented?
undocumented.
You know, in this day and age, in this day and age, that's hard. I mean, in a normal, because obviously to step up and exercise rights, you have to go on documents. So if somebody gets, you know, we discover, oh, this was a child after, and they have to be reported to probate court, right, so they can make sure they get what's entitled to them, their name, their address, all of that has to be listed on probate documents, and all those things are filed with the court. We are in a special time right now. I don't know that I would want to be listed. I think my unofficial advice is to talk to some other relatives and see what options can be done so that maybe you aren't listed as a formal heir of the property. Because I know you all have seen what has been going on. They are getting very crafty on how they find people, right? So you signing up to get $10,000 that's due for you, and you might be opening yourself up to something that's much worse, right? So this is honestly about, you know, self-preservation, right? More than anything else. So that's a great question, but unfortunately to exercise your rights, your name has to go on official court documents that get filed with the court that identify who you are, where you are, and what's going on, and think about what comes along with that.
Gotcha.
What occurs when you have mineral rights? Is that a quitclaim deed or a warranty deed or?
Yeah, so it may be, so some things are not necessarily deeds, because deeds only, it depends on how your rights are manifested, because deeds only deal with real estate, so meaning houses, land, whether it's vacant or not. How we get things in a trust or title them for non-real estate is through assignments and bills of sale and things of that sort. So you gotta kind of look at the asset and figure out what you have to reflect your ownership, and then based on that is how we get it to where it's going. Because some people have air rights, and not air like HEIR, literally air, rights up in the air and things of that sort. So we have to look at how it's titled. What did you get from these people? Similar if somebody has a co-op, right? Mm-hmm. You don't have a deed to your co-op. You own the shares. That's how co-ops work. So we can't do a quitclaim deed for somebody's shares in the co-op. We have to do like a transfer on death or an assignment on death on the shares. So it's all going to be guided by the document that gave you the ownership. That determines how we get it over to the trust or whatever we're doing. And that's for any asset, CDs, stocks, anything.
Or within the county that it's in.
Right, so if you have mineral rights in Alabama, you should not be talking to somebody here theoretically, because you may have a little bit of both. You may have land and the mineral rights, right? So you should talk to someone there. Any estate planning that you get done, estate planning is a state-specific issue. So even though all the concepts that we're talking about are the same across the board, tools are used differently. So for example, labor, right? We talked about it. Everybody does not have that, so you might have to do other things. So always talk to a licensed professional in that state so we can make sure we're doing things properly.
Yeah, I just wanted to.
I think I saw right before Blue, did I see your hand?
No, ma'am.
Okay, I didn't know, oh, you were just getting comfortable.
Yes,
okay.
And these documents that also point out, and these documents, but for your health care too, and who can make decisions on whether you live or die. Because that can impact everything as well. And they may not be the same person who's handling your finances. They could be the same, they don't necessarily have to. Because so one document is going to say one thing, but it may be depending on whether you die or not. So somebody may come in and extend your life. So they can manipulate the documentation. Once they get all the money, they'll pull you off the plug.
So she's talking about a living will, and remember in the beginning I said guardianship and conservatorship, we didn't cover it today, but powers of attorney, living wills, that's exactly what that's dealing with. That's a part of your estate plan too. And those things are important. Today we focused on wills and trusts, what happens when we're not here anymore, but we need to do planning for while we're still here. Otherwise they're going to be down up in probate court. And you're right, living wills, talk about they're different from a last will and testament. Your living will just says if I reach a certain point in my life and my prognosis isn't good, this is what this person can do, right?
And she, you know, human beings are gonna do what?
Human beings.
Every time.
Humans don't. Conservative handles the money.
Correct.
Because the guardians sometimes say they can handle the money.
They can't,
Because they
unless the
own
court
the
appoints them to. Guardians can typically handle just like SSI. If you have property outside of that, you gotta get conservatorship.
Thank you so
As
much.
always, the name Trump, amazing representative, always on the gate. Let's give him one more hand. So, I don't know, I think that call we heard was the call as to where the lunch is. So, what we're gonna do is just take a 2-minute stretch break. And if
It's 3 minutes away.
it's 3 minutes away,
Yes.
that means 3 minutes plus setup, plus all of that.
So go do your thing.
So let's do a 2-minute stretch break, and then we're going to come back and hear from Attorney Alcindor. And after that, we'll have some lunch, and we'll do a game, and we'll have a good time. All right. So just take a couple minutes, get some coffee, and I don't know what else is left. I had the industrials over there, which I was trying to avoid. They're good. So over there, and we'll come back in 2 minutes. So I'm going to introduce Ms. Diana Alcindor, who is the partner of Ms. Attorney Gibson. I should say that the lunch you're about to eat has been sponsored by Great Lakes Legal and Title Connect. Let's give all the further incentive for you all to definitely visit them when you have a need for this type of legal issue. Ms. Ayana Alcindor has also been, the two of them, they kind of tag team us. Today we got them both. But every year they could be one or the other, sometimes both of them. And she's prior to joining Great Lakes, co-founding Great Lakes Legal Group, she was principal at Allied Legal Consulting. She defended clients dealing with minor traffic, drunk driving, domestic violence, major felonies, done all sorts of stuff in family law, eviction, probate matters. She's part of Oakland and Wayne County Criminal Bar Association, criminal attorneys of Michigan. And she's worked with a lot of clients all throughout the metro Tri-County area. She's involved in investigations guarding ad litem, and she says she's a zealous advocate for the linchpin of her practice. She's also an SCEAO approved civil mediator, which is an important role where you are looking at both sides. And it's a great person who is able to do that, to be able to analyze both sides of the dispute. So without further ado, let me bring on Ayana Alcindor to present on renters' rights.
Thank you for that kind introduction, and thank you for the opportunity to speak again. I always like to mention that before I decided to go to law school, I was a student here at Wayne County Community College. I had graduated in 2008 with a degree in biology. That same year, I moved here to Detroit, and I had no idea what I was going to do. Was it nursing? Was it something else? And so while I was working at the school, I had the opportunity to take some paralegal classes, and from there, it's history. But I appreciate Wayne County Community College for the opportunity to work here and learn here and ultimately determine my career path. So whatever you're doing here, keep doing it. So I am Ayana Alcindor. I've been practicing for 11 years now. So let's get into renters' rights. Before we get started, I just want everyone to know that the information provided today or in this presentation is not intended to constitute legal advice. All the information, content, and materials is for general informational purposes. I say that because the laws and the core rules that govern evictions in Detroit and throughout Michigan are consistent across cases, but your particular facts may be different and therefore implicate a different law, a different court procedure. So don't walk into court and say, Ayana said, I'm not representing you. I'm not going to say that. So we could, do I do this one?
You have a,
Can we do that?
take over? Okay. Or you want to go on?
I'm sorry?
You want to go on?
Oh, is it ready? Like ready?
Yeah.
It's up to everyone. Are you guys ready to eat? I can take a pause. Go eat. Go eat.
All right, all in favor? Take a pause. All in favor? Yeah, all right. So, and then we'll give, let's do 15 minutes to go, and then that'll give you time to eat, so you guys do some awesome. And then we can do the pretext. All right, let's do that. So, I guess, how do we just all go over it once?
Yeah.
All right, let's go. When someone says food, I usually jump on the food. That's just me. I mean, y'all polite, I appreciate it.
Yeah, the one that helped Brody.
Oh,
My nephew. That's his house right over there. 31 down.
My son's house
It's 3 blocks down on Avon.
Okay.
Where that red car's in the driveway,
Yeah.
go straight back that way.
Oh, okay.
Go right to his house. Oh, no, I'm sorry. I'm on the wrong side. He's on the other side.
The other side of the.
He goes, yeah, no. That's Curtis right there.
Yep.
So he goes that way.
Okay. So he's on the other side of the Wayne County.
Yeah, he's 3 blocks down from Denise Wellness Center.
Gonna get you something to eat, brother, too?
Yeah, I'm going to in a minute. See if I can do a little bit of this.
My name is Ayana Al-Sindor. I am a partner and co-founder with Great Lakes Legal Group. I've been practicing for 11 years, criminal defense, probate, and family law, and landlord-tenant. So today I'll be presenting on buyer's rights.
That's me.
Sorry. Should still be able.
Recording stopped.
Should I do that again? Alrighty. So again, before we get started, I just want everyone to know that the information provided is for, is not intended to constitute
Recording in
legal
progress.
advice. All information, content, and materials is for general information. And let's move on. So it is essential that you know your rights in order to protect your home. This presentation will empower you with essential knowledge about tenant rights in the city of Detroit. Whether you're facing an eviction, dealing with repair issues or lack thereof, or simply want to understand your lease better, this presentation can help you make informed decisions and take appropriate action. In order to understand your rights in Michigan, in order to understand your rights, I will cover some common Michigan laws and how they apply in real world situations. I'll also cover the eviction process in the 36th District Court and your options for defense. Lastly, I'll highlight resources that may be available to assist you with your case. Keep in mind that many of these resources are free. I want to thank the Detroit branch of the NAACP and the Institute of Continuing Legal Education for partnering with Great Lakes Legal Group in order to provide this opportunity to share this information with you all today. So, if you are a renter in the city of Detroit, we want you to know your rights and have the tools to protect yourself. Unfortunately, many tenants face challenges because they may be unaware of the powerful protections Michigan law provides. My hope is that this information empowers you and acts as a starting point if you are dealing with a difficult landlord, an eviction, or simply want to be prepared for the future. These 4 statutes form the cornerstone of your legal protection as a renter and set clear boundaries for what landlords can and cannot do. First is the Michigan Truth in Renting Act, which can be found at MCL 554.631 through 41. This law restricts landlords from including illegal or unfair clauses in your lease agreement. For example, landlords cannot include clauses in the lease that waive your right to a jury trial, that's if an eviction is ever filed. They cannot force you to pay their attorney's fees if you win in court, and they cannot change the rules without proper notice. Any clause that violates your legal rights is automatically void, even if you sign the lease. Next is the Michigan Security Deposit Act. This protects your rights related to your security deposit. This rule is very strict. Landlords cannot collect more than 1.5 months' rent as a security deposit. And I'll go into more information about security deposit protections later on in the presentation. And violations of this act may entitle you to double damages. But again, I'll get into that more later. The Landlord-Tenant Relations Act. This requires landlords to maintain rental properties in reasonable repair and comply with applicable health and safety codes. This is referred to as habitability or the covenant of habitability. If repairs aren't made, you may have legal options, including holding your rent in escrow. This is a process where a tenant may withhold rent payments until the requested repairs are completed. The rent funds must be deposited into an escrow account with the court. Lastly, there are fair housing and civil rights laws that include both Michigan and federal law that prohibit discrimination based on protected classes, like race, color, religion, sex, national origin, familial status, disability, marital status, age, gender, gender identity, sexual orientation, and source of income, including Section 8. With our president, these have been changing, so keep your eye on the news. Discriminatory practices in renting, lease terms, or evictions are illegal. So now that we've covered the law, we'll next discuss notice requirements as it relates to residential renters. Courts require specific notice before an eviction complaint or case can be started or filed. These requirements protect renters from being caught off guard and ensures due process. Understanding these timelines, Understanding these timelines is critical. Many evictions are dismissed because landlords fail to provide the proper notice or within the specified amount of time. The reason the landlord wants to evict a renter will determine the type of notice and the notice period that's required. The notice will also determine what remedies are available to the landlord if they are successful in court. That means whether they can recover the property alone or the property and money damages. The notice requirement applies to both the landlord and the tenant. It says the days the landlord must wait before filing anything with the court and the time limit for you to vacate or remedy the alleged situation or violation of the lease. So let's look at all of these. If the landlord alleges that you have not paid rent, they may serve you with a demand for possession and give you 7 days to make payment or vacate the property. If you do not make payment or move within the time period, the landlord can file an eviction action, which means that starts the eviction process. If the landlord alleges that you've made damages to the property or caused a health hazard in or on the property, you must be given 7 days to vacate or remedy the damage or hazard. If allegations relate to illegal activity, the notice to quit must give you 24 hours to vacate. You certainly want to contact an attorney anytime you receive this type of notice. Taking any action may constitute an admission of guilt to a crime, which we certainly don't want you to do. So you want to proceed with caution. For a lease violation other than non-payment of rent, for example, having a pet or a roommate that's not allowed by the terms of your lease, the notice must give you 30 days. If the landlord alleges you have stayed in the property longer than what is stated in your lease, or if you're a month-to-month tenant, you must pay the rent or move within 30 days. And keep in mind that self-help evictions are illegal in Michigan. A landlord cannot lock you out, prevent you from accessing the home, shut off utilities, remove your belongings, or change the locks without a court order. Even accessing the property without giving you proper notice is a violation. If you believe your landlord has committed an illegal eviction, a constructive eviction, or engaged in self-help, you may sue for 3 times your actual damages or up to $200 per day. This is a good time to talk about damages. For renters, actual damages includes money loss or out-of-pocket expenses. So it's critical that you save all of your receipts. If you don't have receipts, make sure you have your bank statements or something in writing, canceled checks, a ledger, to evidence that you've been making payments or that you've given your landlord notice of repairs or that you're moving out. You want to make sure that you have everything in writing. And if you're ever prevented from accessing your home, call the police and then call an attorney. Okay. The eviction process can seem complicated, so next we will discuss that. The first step is the notice, which I just discussed, whether it's a notice to quit or a demand for possession. It can be mailed to you or tracked to your door. You don't want to ignore any notice that you receive. At this point in the process, after you've received notice, nothing yet has been filed with the court. So that's a great opportunity to see if you can negotiate with your landlord, come up with the money if it's a non-payment of rent situation, but you don't want to ignore it. after the notice period expires, step 2 is the court filing. The landlord will file a summons and complaint with the court along with other required documents. You must be served with the summons and complaint. Service is handing the documents to you. That's typically delivered by a sheriff or a court officer, but not the landlord, unless you consent in writing. So also don't sign anything unless you talk to an attorney and you thoroughly understand what you're signing. Step 3 is the court hearing. This is often called the first hearing at 36th District Court or the pretrial conference. The proceeding is held by Zoom. Your first hearing is always on Zoom. And then the subsequent hearing is in person. At that hearing, you can request to speak with an attorney, and you'll be given a subsequent hearing date that will be in person. Failing to appear may result in a default being entered against you. So it's important that you attend all court hearings. If you receive a notice of hearing and you don't understand it, you can contact the court or contact an attorney. Step 4 is filing your answer. The answer is your response to the landlord's complaint. There are time limits for filing your answer, and you want to make sure that your affirmative defenses are included in your answer. If they're not, the court may not consider your defenses, which is your evidence. So it's very important that you include those things. Step 5 is the hearing, also called a subsequent hearing or another pretrial conference. Both sides have the opportunity to present their evidence to the judge. In addition to filing the complaint with the court to start the eviction process, the landlord also has to file the deed for the property, showing that they have ownership rights, their certificate of occupancy, and the lease. If those documents are not filed with the complaint, you want to make sure you bring it up in your hearing. Those are required documents. If a landlord is claiming to be the owner of a property, if it can't produce a deed with their name on it, the eviction is going to be dismissed. If the landlord is successful at the court hearing, the next step is the issuance of a writ. The landlord has to wait at least 10 days after the judgment is entered. And that writ is what will actually allow a court officer or sheriff to remove your belongings from the property. And it's often called the execution of the writ, where they actually go into a property and remove belongings. It is important that you don't give up. If you're not successful in court, reach out to an attorney. Hopefully you reach out to an attorney before you've gone to court, but if you're not successful, reach out again and see if there's any resources available to you. Maybe the judge misinterpreted the law, they didn't consider all your evidence, or one of those required documents wasn't filed with the court and the judge ignored it. You want to make sure that you preserve your appeal rights, so you have to act quickly. Any questions so far? I've been talking about.
Does the landlord have to be present at the in-person hearing, or can they use a property management representative?
It depends. If the landlord's, business or the lease is written in the name of an LLC against renter, then they have to be represented by an attorney. It sometimes depends on the judge in the courtroom whether an agent of the landlord can appear in court on their behalf. Certainly an attorney can, but if someone is unable to show their agency relationship with the landlord, I don't think the case can proceed. So it depends.
Okay, I had brought it up because I know that most people who own homes may be out of state.
Right. So a property management company may stand in that instance, but they usually have an attorney that represents the property management company, and they would attend the hearing.
Okay, you said a deed of ownership has to be provided to the court.
Correct.
Now, if the person who's standing there, the landlord, their name isn't on the deed, then what happens?
They have to show some type of ownership.
What other?
So maybe they have a contract with the owner, and that's how they were able to execute a deed on that person's behalf.
I was on the deed. I personally was on the deed. That's why we talking to the department. And they had me evicted. And I was on the deed. And I'm still, as of the end of September, still on the deed. Even though the probate court judge voided a quitclaim deed. Again, I had the warranty deed. No legal description was on there because your partner asked me was there a legal description on there. It's part of the
listening to something on Zoom.
I don't know. I would need more information.
Okay.
But if you're an owner of a property, you typically can't be evicted.
No, I wouldn't be.
In the probate court or at 36th district?
36th district. And I tried to get an emergency hearing with probate, and they never did.
And they only invalidated one deed, not the warranty deed.
I never had a quitclaim deed. That's my whole argument from day one.
So the only deed that gave you ownership was invalidated? Okay. So at that point, then you're no longer the owner according to the court, and then they can proceed with the eviction.
Even though they voided a quitclaim deed.
Correct. Any voidance by a court of a deed ends any ownership interest.
Okay.
And then at that point, you're just a renter or technically a trespasser or a lease.
Yeah,
But, yeah,
You
it
told
can
me
get
you were
complicated.
in the process, you were entitled to representation.
You know what, they did offer me representation, and I was in the intake area, and they postponed the hearing.
That happens a lot.
They postponed the hearing, I never spoke to the attorney who was gonna represent me, who was nonprofit. And they, how can you speak for someone if you've never even consulted? You know,
Well, they certainly shouldn't, and that sounds like an attorney grievance situation.
Okay. Okay.
Okay, so those are the steps of the eviction. Let's talk about common defenses. Common defenses. Remember, these defenses must be in your answer, or they may be waived, which means they're not considered by the court, even though they may have occurred. One of the first or most important defenses is retaliatory eviction. This is when the landlord sends you a notice to quit or a demand because you reported code violations, requested repairs, joined a tenant rights organization, or exercised some other legal right. So because you've exercised some right, the landlord gets upset and then sends you a notice to quit. They're not allowed to do that. Another defense is improper notice or filing. If the landlord threw some paperwork at you one day, that's not proper notice. You have to be properly served with the summons and complaint in order for the eviction to take place or for the case to proceed. Like I said before, many evictions are dismissed because of defects in service, which is a violation of due process. Another defense is set off for repairs. You are allowed to withhold rent after the landlord was given notice of necessary repairs and they have not been made. If you subsequently make those repairs at your own expense, any rent due should be offset or reduced by your out-of-pocket expenses. This defense goes hand in hand with the next, which is breach of habitability. Of course, the landlord has the legal responsibility to keep the property in good repair. If they do not, and you make those repairs on your own, you're entitled to some compensation for making the repairs. And even if you don't make the repairs, you've reported that there's something unsafe on the property, like mold or, I don't know, chemicals, something, and the landlord has not remedied that situation, you want to make sure that this defense is in your answer to the eviction. Another defense is acceptance of rent after notice. If you receive a notice to quit or a demand for possession and then subsequently pay your rent, the eviction should be dismissed. Should.
I was saying that because I know that that's what you said, should be.
Yes. And then finally, discrimination or harassment. If the eviction is motivated by discrimination or harassment, the case could be dismissed. The landlord, although they technically are a bill collector, they can't call you in the middle of the night asking for rent or discriminate based on those protected classes that we spoke of before. There's a good chance you can get your eviction dismissed if you can prove these defenses. Okay, repairs and rent escrow. Remember, your landlord is required to keep the home in good repair and comply with all applicable health and safety codes. The key to enforcing your rights is documentation. It's not enough to simply tell the court what the landlord is doing wrong or to tell them your defenses. You have to present evidence. Always notify your landlord in writing and keep a copy of what you send to your landlord and what they send to you. Also take photos or video of any problems or repairs that you believe need to be made. When repairs are not made, you can send notification in writing to the landlord describing the problem. Again, send pictures or video and give them reasonable time to repair. If the repairs are not made, you can file a complaint with BC, Detroit's Building Safety, Engineering, and Environmental Department. You can deposit your rent into an escrow account until the repairs are made, but this is not indefinite. Once the repairs are made, you need to start paying rent again. And the back rent, maybe. And again, repair and deduct. You may make emergency repairs at your own cost and deduct it from the rent. There are limitations on what repairs constitute, or yes, what repairs are considered an emergency repair. So you want to contact an attorney before taking any action. All right. Security deposits, here we are. Counties can often lead to disputes between landlords and tenants. Michigan has clear rules to protect your deposit and ensure that you receive it back after you vacate the property. The security deposit cannot be more than 1.5 months' rent. Be sure to do a move-in inspection and an inventory and document any damage or repairs that are needed before you move into the property or shortly after your move-in. During your tenancy, while your lease is active, the landlord cannot deduct rent payments from your security deposit. Upon moving out of the property, within 4 days, you must inform your landlord of a forwarding address so that they can send you your security deposit. The address is where they will send a check, and we often tell our clients to use certified mail. We advise our clients to use certified mail so that any notice that you send to the landlord, you have a record of when it was delivered to them, where it was delivered, and even what time. So the landlord can't say, I didn't get a forwarding address, so I didn't return the security deposit. The landlord has 30 days from your notice to provide an itemized list of damages and repair costs. They have 45 days to return the remaining balance of your security deposit. They can only charge for damages beyond normal wear and tear. So it has to be actual damages. A dirty carpet, a few scratches, or a nail in the wall, that's normal wear and tear that every tenant is expected to make to a property. But if you have damaged the floor so bad that the subflooring has to be replaced, that would be something that they could charge against your security deposit. You have legal remedies if your landlord does not return your security deposit. You may sue for double the amount of the security deposit. Any questions?
Maybe it's a matter of semantics. When they say first, last month, and security.
What do you mean by that?
When most tenants move in, apartments, landlords may ask for, but isn't it all security deposit actually?
Well, you're paying for your first month's rent. That should be the first month. if you receive a ledger or any type of confirmation where it looks like that might have been included in your security deposit, contact an attorney. Okay. Fair housing is a fundamental right. Both Michigan, does someone have a question? Okay. Fair housing is a fundamental right. Both Michigan and federal law prohibits discrimination of protected classes. We previously discussed those protected classes, but they're provided here again. The landlord, any landlord, cannot refuse to rent, use different screening criteria, advertise to discourage a protected class from applying, provide different lease terms, or refuse reasonable accommodations based on someone's protected class. Reasonable accommodations comes up a lot, so it's important that we understand what is a reasonable accommodation. This includes, among other things, like the landlord allowing a service or emotional support animal, permitting accessible parking spaces, and allowing the installation of accessibility features like grab bars or ramps. Recognizing discrimination is not always obvious, and in order to prove it in court, you'll need more than just your word. But look for these red flags, like being told a unit is unavailable, higher security deposit or rent, intrusive questions by a landlord or property management company, denial of your application without a clear explanation, or if you see that rules are applied differently to different tenants, you want to contact an attorney and also take action.
Sometimes on a rental application, they'll have an extra charge for a pet, but with service animals, they don't have to pay extra rent.
They should not. So you want to provide the landlord with documentation that it's not just a regular animal, but a service animal. Yeah. Any other questions? Okay. And some of those action steps is to document everything, file a complaint, contact an attorney, and make a report to your local fair housing organization. And here's a list of some helpful resources. I know that 36th District Court has Lakeshore Legal Aid. Those are the attorneys that actually advise litigants or tenants when they are involved in an eviction case. The court staff is not allowed to give legal advice, but if you are involved in a case, there are lawyers that can be appointed to you. The United Community Housing Coalition, the NAACP, and their attorney resources are all free resources that you should definitely reach out to. Also, Great Lakes Legal Group is available. We usually charge a flat fee for most landlord-tenant cases unless there's a trial. So remember to protect yourself, demand written notice, and save all written records. Make sure you put everything in writing and keep copies. Never ignore any court notice or any paperwork. Seek help immediately and don't wait. And know what is illegal and what may constitute a violation of your lease. I advise you to have an attorney read over your lease before you sign it. It may avoid a lot of issues further down the road. Remember that housing is a human right. You deserve a safe, habitable home, and Michigan law is on your side. Michigan law is very favorable to tenants, so if a court or a judge finds out that a landlord has been unscrupulous, they come down on them pretty hard. So make sure you have your evidence ready for them. Also, don't let landlords, their agents, or their attorneys bully you. You're never, ever, ever required to sign anything. That is your choice. So once you sign, you may be giving up rights. Talk to an attorney before you sign anything. Stand firm, seek help, and fight for your home. I want to thank all of you today and today's sponsors for this opportunity. If you have any questions or concerns, please don't hesitate to reach out to Great Lakes Legal Group and NAACP. There's a lot of resources here for you.
All right. Well, I had that before. But, okay, if you have a service, as opposed to an emotional support, and can the landlord take documentation that is actually a service, as opposed to just a pet that you're trying to get in there?
I believe the law protects both, both emotional support and a service animal. So yeah, make sure you talk to an attorney.
Okay, as we all know, fair housing is not always something that was guaranteed to us, and what was redlined and all that. When did most of these laws come into effect?
I couldn't tell you that.
So are the same laws?
Late 60s, early 70s?
Fair housing, I don't think it was about home property back then, and I know I bought it in one of them.
We appreciate your honesty.
Any other questions while I Google yours?
We were talking about property managers in terms of individuals. Think about seniors in particular, as a social worker. I hear from a lot of seniors who are living in apartment buildings, and their property manager is increasing their rent without informing them, one area. And another area, some of the seniors have concern about the lease. Many times they're not understanding just the lease. So should they take that lease that you were applying to, take that lease to Michigan, I think I saw Michigan Legal Services and your resources, to help many of the seniors. That's what I would recommend, we get social.
Absolutely.
The Michigan help, because managers are just taking advantage, really.
Absolutely. They should definitely have someone look over the paperwork. I know there are limits on how much rent can increase year to year, and especially for seniors. We also special rules for that as well.
And what happened to HUD? HUD still around? I know all the changes was going on in the federal government. Some of the seniors have a special program.
I believe so, you know? We're under a shutdown right now. So.
Right.
1968.
1968.
The Fair Housing Act was enacted.
Okay.
You're welcome.
Now you know how to do that.
Right.
Any other questions? All right. Well, thank you for having me.
Always very informative. Thank you again. Why don't we give another round of applause? And now,
Bridget, she said she wanted to thank our sponsor, but they are.
Right. I didn't pick up on that.
Right.
I seen her in her modesty said, I want to thank the sponsors, but she is one of the sponsors of today's event. So again, thank you for helping to make today possible. And again, great law firm. I definitely recommend reaching out if you need. Is it game time? All right, so now we get to play the game. You know the game, you know the drill. You already, for those of you who've been here, those of you who not, we're going to turn it over to Ms. Leah Jackson from the branch. She's going to lead us through Kahoot. I hope you've been paying attention. I don't know if there's a prize for the winner of the game. There may be a couple of good girls over there. So, you know, maybe you can get that, but we'll figure that part out. But take it away, Ms. Jackson.
All right. Get ready to test your knowledge, huh? Thank you.
Okay, guys, are all of you familiar with Kahoot? Yeah. So you're gonna scan the QR code, you can pull out your phone and go to the camera and scan the QR code, and it should take you to the link. If not, you can just go online and type in Kahoot. K-A-H-O-O-T. If anyone needs help, they can raise their hand and we'll come around and help.
I just can't see it, I have to come up.
You can zoom in, I got it.
You can zoom in. Well, I zoomed in. Zoom in.
If not, you can search it up on your search engine as well, K-A-H-O-O-T.
I had to go into the Wi-Fi in here because my cell signal wasn't strong. That's why I had to.
K-A-H-O-O-T.
Okay.
You can search up Kahoot.
Search for
Go to your search engine.
Yeah, but if you see that QR code? Oh, okay, well then you gotta go to.
Search up K.
No, you can go online. You know what you do? Go to your camera. Point the camera at the screen up there, and you see that QR code.
It's right here.
Yep. And you're gonna put in the game pin.
Oh, okay.
The pin number right there?
Yep. And then put in the nickname. Anybody else need help? Are you on there?
Now we're gonna get.
You don't have to.
I don't have the app. Food.
All right.
Online, and then you wanna put in the game pin. Did you get it?
Okay, now just type in your nickname. Mm-hmm. Now what I did, I just used my initials, so in case I bomb, no one knows who it is. But then if I win, I can say, oh, this is me.
You're on there? Well, yeah.
Number 11.
Oh, yeah.
Take out your
I disqualified my win.
You can, I did. They gave me one. It's just like something better.
Okay, is everyone connected?
Yeah.
Okay.
Let's go, let's go.
We're waiting for one more person. first Kahoot question is gonna be, and whatever you think the correct answer is, you just press the shape. This is a multiple select. Trust. They help protect the value of assets and avoid probate. They aren't useful. Trust must include a family member as the trustee, or trust includes a guarantor slash settler, trustee, and beneficiaries. And this is going to be multiple correct answers. Okay. It's a really quick game. So the correct answer for trust is that they help protect the value of assets and avoid probate. And they include a guarantor slash settler, trustee, or beneficiary. So somebody clicked on a trust must include a family member as a trustee. I'm not gonna air y'all out, but that was the incorrect one. And we all didn't put down that trusts aren't useful, which is really good.
We all barely got it.
Yes, the thing
You gotta be really quick about it.
yes, the thing is speed, but accuracy too.
Who's love 312?
It should have said 313, but it's I. According to I.
Are you from Chicago?
Tierra. It's me.
Okay, this is true or false. A title is the ownership rights to property. It determines limits to sell and insurance to mitigate risk. Is this true or false? True. So most of us got that right. It is true that a title is an ownership rights to property. It determines limitations to sell and insurance to mitigate risk. Who all said false? It's just a learning moment, that's all. But
We're all winners.
in my heart, you guys are all winners. Okay, Tierra, you're still at the top.
Of course I am.
Okay. This is a multiple select. What is the Landlord-Tenant Relations Act? It's going to be 2 answers. This law requires landlords to rent to any and everyone. This law ensures that renter security deposits are protected by strict rules. This law establishes the covenant of habitability. The home must be livable. Okay, so the 2 that were right was that it established the covenant of habitability. Dang. Oh, this give me. And the home must be livable, or this law requires landlords to maintain rental properties. And it seems like some of us got that correct.
I was trying to find this in there, but I ain't thinking
Cheers,
about
still
that.
up there. Your will does not automatically avoid the probate court. It does not give instructions on who will receive your assets. It does not establish who the personal representatives of your estate will be, or it does not nominate guardians and conservators of your minor children. So it's the first one. It seems like most of us got this one correct as well. Your will does not automatically avoid the probate court. Paying attention. Detroit's housing code. The Detroit Housing Code requires landlords to collect rent without safety inspections. The Detroit Housing Code requires landlords to keep property maintained. Does the Detroit Land Code require landlords to obtain a certificate of compliance and lead safety inspections? Or does it require landlords to obtain a certificate of compliance only? So it was Detroit Housing Code requires landlords to obtain a certificate of compliance and lead inspection safety. So that was the correct one. I know that the other one was misleading, but it's going to be this one instead. There are only 20 seconds you get for each question. You see the little counter in the dice.
I took that one, it said it was correct, so whatever. Somebody get who's RGM? RCM.
What is a quit claim deed? A deed that guarantees lifetime ownership of any property you live in, a nickname for a quit claim, a contract that lets you quit your job and claim unemployment benefits, or a legal document that transfers ownership interest from one party to another. A quit claim deed. So, a quit claim deed is going to be a legal document that transfers ownership interest from one party to another.
I'm having some technical issues over here. It keeps telling me it's incorrect.
Oh, we have a new leader on the board, RGM.
No, I put it.
Oh, okay.
Yeah, I know, right?
Testices and intestacies are the same thing, true or false? Are they the same thing? Look at y'all. So that is correct. They are not the same thing. What is a title company? A company you trust, a company that deals with titles, a neutral third party of a real estate transaction, or a non-neutral third party of a real estate transaction. What is a title company? Okay, so majority of us clicked on the right answer, and the right answer was a neutral third party of a real estate transaction. It is not just going to be a company that just deals with titles. It does have to be a third party, and it's also required to be neutral, so it can't be non-neutral. True or false? Michigan law requires landlords to follow strict notice procedures before filing for eviction. True or false? True. Oh, you guys are getting so much quicker too.
Yeah, right.
Process of elimination.
A probate is the administration of a deceased person's estate, regardless of testacy, is received at the time that property is purchased, is not required when a person dies with property title in their name alone, or it's not important.
Oh, dang.
Okay, yes, the majority got that right. A probate is the administration of a deceased person's estate, regardless of testacy. Our last 4 questions. What are usual reasons for a tangled title? Incomplete documentation, inheritance issues / lack of property estate planning, errors, or someone tangled the title. And this is going to be a multiple select, so there's multiple correct answers, and I'll give you a hint, it's 3 correct answers. There's only 1 wrong. You only had 3 seconds.
I did admit.
Okay. So majority of us clicked on only the one for incomplete documentation, and yes, that is a correct answer. Another correct answer for reasons why a title may be tangled is inheritance issues / lack of proper estate planning, as well as errors. A tangled title can't be tangled if someone just tangled it. Okay. Why are renters' rights important? They help you know your rights and protect your home. They aren't important. Renters don't have rights or know your rights, but not to really protect your home. And there's only 1 correct answer for this one. Okay, renters' rights are important because they help you know your rights and protect your home. And we all know that they are important and that renters do have rights. Okay, Richard. True or false? Michigan is not one of the few states that recognizes a ladybird deed. Is that true or false? Does Michigan recognize a ladybird deed?
Oh.
Or is Michigan one of the states that do not?
Not.
So yes, we majority got that right. It sounds like Richard got that one wrong. Michigan is one of the few states that
call anybody out or anything.
Well, I'm just rooting for someone else, boss lady.
We don't want to put any pressure on you.
I don't know who that is, but congrats. We finally got past Richard Mack. Yes, Michigan is the state that recognizes the ladybird deed. This is our second to last question.
Come on, boss lady.
Your options when repairs aren't made: written repair request, a rent escrow account, file a code complaint, or repair and deduct. There's going to be multiple correct answers for this one. Okay, so all of these answers were correct. So your options when repairs aren't made within your home under your landlord is that you can write a written repair request. You can also rent escrow account, file a code complaint, and repair and deduct it from your rent.
Wait, I got protest. I put all 4. They only had me 3. I got a protest.
I don't know if you would let me that.
I want to appeal. Oh.
You don't really have a player. Right. A quit claim deed is beneficial. Is that true or false? And this is our last question. A quit claim deed is beneficial. It is or isn't beneficial? Well, that's not what it said in your PowerPoint presentation. It said that it was beneficial. A quit claim deed is beneficial. Let's see who our winners were.
Come on, boss lady. What we got?
Notary Nance. Richard.
Oh, beat me out.
And
I protest. Congratulations, boss lady. I still protest.
guys.
The winners get up and take a picture? Can we get a picture of the winners?
Let's after the protest. Let's file an appeal. Man, congratulations, boss lady. All right, so I think that concludes our program. I would like to end on a note which allows you to kind of take stock of the lessons that you've gotten from this, that you received.
Voting has consequences.
Oh, that's right. We did say voting has consequences.
That's you.
That's me?
Yeah.
Oh, okay. So, I don't know that I have to do much more than tell you or remind you about what's been happening in the news the last 9 to 10 months for you to get an indication that voting in fact has consequences. Interestingly, I'll say this. You've seen what our 47th president has been doing to destroy the systems that we all know and need in our federal system, our federal government, our federal judicial system, and the agencies that run day-to-day life in your receipt of Social Security. I just heard a report, what was it, yesterday, that because of the government shutdown, people who need assistance with Social Security benefits are not able to call anyone and get answers to how they can get their checks, as one example, because they have people who are staffed, but because the furlough and because the staffing is way down, and most of the government is actually shut down from the federal government. You can't call in if you're a Social Security recipient and you have a need to find out why your check is not yet arrived, or questions about getting your check, and you're not sophisticated enough or going online, you don't have anyone to talk to. Medicare, Medicaid, I mean, just the list goes on and on and on. And just talking about that election, Donald Trump won Michigan.
He sure did.
In the last November.
He stole it.
He won Michigan. He lost Michigan in 2020, claimed it was stolen from him, but he won Michigan in 2024.
He stole it.
And you know, many of us believe he stole it. But the point of it is, you can't you can't steal an election where enough voters vote against you.
That's right. You cannot.
There's nothing you can do as a candidate to steal an election if enough voters go to the polls and vote against you. And the turnout in Detroit, unfortunately, was low. The turnout across the state, unfortunately, was low. It was actually abysmal. And so what that meant is that not enough of us, I put my finger on myself too, went to our neighbors to say, make sure you vote. However you vote, make sure you go out to vote. Not enough of us, shared messages on social media, Facebook, Instagram, Threads, whatever it is you have. Not enough of us encourage people to get to the polls. And so now all of these things that we see happening, all of these impacts on the prices, when you go to shop for this Christmas season coming up, when you go to the grocery store and you see prices escalating despite promises that prices were going to drop, and when you see things that normally you purchase that come from overseas through tariffs are making them go through the roof, but when you see bills like the Voting Rights Act, which has been around since 1965 and has protected the right of black and brown voters from being basically watered down to non-existent, in that case is not going before the Supreme Court this term. And it's very, what's been predicted is that the Voting Rights Act will essentially be eliminated. I'm glad I can't read, my glasses is bad. What does that say?
Remember to say that.
Oh, right. We're a nonpartisan organization. We are a nonpartisan organization. We do not support any particular party. We only support the issues that those in the policies that the party the issues in the policies can go to the various parties and say, are you with us or against us? I don't think there's any guesses to who's against us in this time around. But the Voting Rights Act is in front of the Supreme Court, and it may very well be no longer. And have things gone differently in 2016, that would not be, had we as voters gone to the polls and done something different than what we did in 2016, that would not have been an issue. Because the Supreme Court makeup would be different than 6 Republicans, 3 Democrats, as it is today. Again, we got to look at us. In 2016, had a different person won versus President 45, there would have been a different Supreme Court person, different Supreme Court people put on that bench, and we wouldn't have to worry about the loss of voting rights across the country. Very quickly, I'll end with this. Very quickly, what that means is essentially you have the way that voting lines are drawn in all the states across the country. It's done by the elected state leadership. So a voting line is, we're right now in Northwest Detroit. We are in, what is it? This is 13. District 13 for the congressional district. So the state house and senate, they get together and they draw us into
like an S.
District 13, and it looks like an X. And so basically the politicians decide what groups of people and voters are going to be in which specific congressional districts, in which specific state house districts, which specific state senate districts. And they make those decisions, so basically it's the politicians deciding who's going to vote for who. And what you have, primarily in Republican-controlled states in the South, but also in Ohio, and also in some other states that are Republican-controlled, is you have those Republicans deciding, I'm going to take this group of black voters and split them up into different districts. So instead of there being a district of 55 or 60% black, we're going to have 3 districts of 15, 20% black. So what's that do to the black vote in those districts? It waters it down. And it means that the rest of the people who are going to be white primarily, are going to be Republican primarily, are going to vote for a Republican congressperson. So that means that while Louisiana, as an example, I believe is almost a 3% black, they have, I think, I can't remember the numbers now, it's like 5 of their 13 seats are Democrat, and it's going to be dropped down to 2. I mean, it's that sort, and the reason, and the other way that they do it is they take these districts and they say, instead of 55, 60% black, we're going to put more black people, we're going to make it 80% black. So they either pack them or they crack them. And that's what happens. And that's going on, and that's illegal under the current Voting Rights Act. The current Voting Rights Act makes it illegal for you to, as a state, say, we're going to put too many black people in a district, or we're going to split black people across various districts, and it mentions specifically race. It's illegal to do that under the current Voting Rights Act. The Supreme Court is going to decide this term whether or not that's still the law, or whether or not the Voting Rights Act remains. And because Donald Trump has 3 picks on that Supreme Court, the fact that he was able to win back in 2016 means that the people he put on the court are going to determine whether or not that racism is allowed to occur. And what he just did in in Texas, is he took, that state's got 35 congressional seats. I may be off by the numbers a little bit. 35 congressional seats, and of them, 13 were Democrats, even though the state is majority minority. Say that again, the state is majority persons of color. When you consider Hispanic and African Americans and Asian, it's majority. By the numbers, it should be majority Democrat. But it's been so gerrymandered, they stuffing people of color in the districts and they spread them out over districts. Of the 35 seats, it's already got 13. They just passed a map against the law, because the law says you're supposed to do it every 10 years. But what Donald Trump says literally is, I want to change the congressional districts in Texas so that next year in 2026 we could get even more Republican votes. So I want to spread black people out even more. I want to push black people into other districts even more. I don't care what the census law says, but we're only supposed to do that every 10 years. I'm going to do it now. I'm going to go to the Texas House and say do it now, so that in 2026 Republicans will retain the majority, so we can get 5 extra Republican votes out of Texas. It's against the law, but I don't care what the law says. That's literally what Donald Trump just did. And literally the Republicans in Texas went and did it. And that's when you saw, okay, I'm sorry. See how I should have told you? I'm sorry, y'all. All right, let me finish it up. So, what you saw in the Republicans, the Democrats in Texas, was the reason why they left the Texas state legislature, because they did not want that racist bill to go through. They, whatever reason, they decided to go back, and they went back, and it went through, and now that law has taken the Democratic seats in Texas from 13 potentially down to 8 of the 35. And there are going to be at least 3 or 4 black and brown congresspersons, including Jasmine Crockett, running against another black or brown congressperson because of the racist bill which intentionally spread people across based on their race. That's the consequence that voting has. Had Michigan gone for someone other than Trump in 2016 and 2024, that would not have happened. So, voting has consequences. I hope I got it straight. But we all straight on that. So, on that positive note, we want to thank you all for your participation. And we will see you next next month in November.
November the 8th.
November the 8th, after Election Day. Vote November the 4th, Tuesday. October the 30th, we're going to be at the branch at 6. Election protection, we need you. And we will see you November the 8th. Yes, ma'am.
And we have an event next Saturday, Votes and Buys. We get educated on the election process, why you should be involved and why your voice counts. Please visit our website. It's next Saturday from 3 to 6 at the Millwright Skill Training Center.
Yes, vote by October 30th. Thank you all. We'll see you next time.